Item for delivery of orders, item number 59.
Petition dismiss.
Obliged.
Put listing of IL. Any day next week.
Negative Lordship, I beg to make a
27.
prayer for
27.
listing of an it's an MSc appeal, my lord. Any date on the next week, my lord.
Next
Under
week.
orders columns,
Is there any urgency?
my lord.
Is there any urgency?
My lord, the urgency is that I am being told that the claimant, the respondent is very ill.
Hmm. When do you want?
Any date of this honorable
23rd.
oblige, my lord.
So I have to mention item number 21.
Item?
21. The London Council P. Ahmed is out of station.
Yes, that is also not received, my lord.
No.
Mr. K.K. Parasar, learned additional PP submits that he has not received the case in and prays for granting him some more time. Where is allowed, recessal is the matter on.
30. 30.
Short date?
13.
23rd or 24? 23rd. 23rd.
May please, Your Lordship. But item number 8 to 13, my lord. Well, this matter otherwise substantially was heard. The petitioner side had completed, my lord just said Jampi heard this matter on three occasions.
Hmm.
We were supposed to file, submit our argument, my lord.
Hmm.
So let this matter come up on 19, my lord.
Item number 8 of
8 to 13,
all are tag matter.
all are
Yes.
tag matter.
So
Petitioner side had completed their argument.
Yes, Your Lord.
They lacked
before court number 2.
court
Yes, Your
number
Lord.
2. Court number
Okay. Both the parties are represented by their English counsel. It is submitted at the bar that the matter was already heard. Matters have already been heard by a coordinate bench of this court. Accordingly, it is provided that recessal lists all those matters before the said coordinate bench. Should I fix that?
My lord will fix 19th. Otherwise, the matter was fixed on the last Thursday,
Yes,
but
Your
it did not get, it was not listed.
Okay.
Met His Lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 26, my lord. Well, here I need to obtain some instructions in the matter, my lord. It may be passed off for a week, my lord. Then for a week.
Mr. Mishra, learned counsel for the petitioner. With consent from the other side, price for adjournment of the case for the day. Pair is accordingly allowed.
Oblige, Your Lordship.
May I please, Your Lordship? My lord, item number 5 become instructions, my lord.
Item number?
5.
Why?
My lord, the matter was regarding head post of school, FS school, Your Lordship, and the petitioner has already been superannuated from his service.
Your good name?
P. Kolika.
Mr. P. Colita, learned counsel for the petitioner submits that this matter become infractious and accordingly he pays that the matter may be closed. In view of the submission of Mr. Colita, learned counsel for the petitioner, this matter stands closed, being infractious.
May it please your lordship, I beg to mention for listing of an IA or for withdrawal of the deposited amount
When?
for the register. Monday, my lord. Obliged.
Your lordship, I beg to mention listing for MSc appeal, your
When?
lordship. 24th,
In which column? In which column? Order or for
order,
order? When do you want?
24, your lordship.
24.
Nice.
May please, Your Lordship. I beg to mention item number 55 and 56 with the consent of the other side. matter may be taken up after 2 weeks.
Yes,
As per with the consent of the other side.
55 and 56.
56.
What is the ground?
Ground, my lord, my senior's relative was expired. Which
You for the petitioner or respondent?
petitioner?
I'm for the
Petition.
respondent lordship.
Respondent.
Lordship, in item number 56, kindly a date may be fixed.
56.
Yes, lordship.
When?
After vacation,
Before vacation, any date.
before vacation, hearing matter.
After
Before vacation. Before vacation
Yes,
may not
for-
be possible.
most convenient time.
Immediately after
After
vacation.
Reopening, yes. As agreed by learned advocates of both the parties, recessal is the matter immediately after reopening of the application.
Highly evidence.
Yeah, pray for listing of who I am, my lord, on 20.
20,
20.
COVID possible?
20.
Okay.
Oblige. May it please the lordship. Also, I'd like to mention a fresh CRP method for listing.
When?
18th, madam.
18.
Trial court matter is fixed on 19th.
Okay.
Oblige.
Items from daily list, promotion, item number 1.
May please your lordship. The present petition is filed by the petitioner challenging the order dated 31st July 2024 passed by the Learned Court of Munshi. Now the civil justice junior division number, junior division Nolbari, entitled suit number 155 of 2021. By the said impugn order, the Learned Trial Court below allowed the defendant respondent to amend the plain. Though the issues are already, some of the issues was considered as a preliminary issue and was decided. So after deciding the issues, the Learned Trial Court below allow the defendant respondent to amend the WSU. The main, the impugn order is Annex 10, my lord. Annex 10 at page 80, my lord. Then the relevant part. is there are 10, my lord, at page 87. Prior to that, I mean, be permitted to submit, sir. My lord, the present petitioner, as a plaintiff filed title suit number 155 of 2021 before the Learned Court below. Praying for a decree that the present petitioner plaintiff is a tenant under the respondent defendant. So the present petitioner prayed for a decree that to declare that he is a tenant under the defendant, and next prayer was that defendant may be restrained to disturb or illegally dispose the plaintiff petitioner from the suit premises without following due process of law. The defendant, present petitioner, appeared before the Learned Court below and filed written statement. On basis of the written statement, the Learned Trial Court below framed 2 issues as preliminary issue. I have annexed the copy. On basis of an application filed by the defendant, the main issues will whether the suit is maintainable and whether the Learned Trial Court below, yes, at page 41, dear petitioner, whether the page 41
Those are preliminary issues.
preliminary issues, whether the suit is maintainable in law for the time being in force. Second, whether the jurisdiction of the court by law for the time being in force. So these issues were decided against the plaintiff present petitioner. Against that, we preferred a misappeal before the Learned Court of Civil Judge Senior Division, Nalbari.
Mm.
The Learned Civil Judge Senior Division, Nalbari decided the misappeal against us, Your Honor. Against that, we come up before the Honorable High Court, Your Honor,
Mm.
and the Honorable High Court by order dated page number Annexure 7, please. Annexure 7, Your Honor.
Mm.
Please. Page 59. Page- Allowed the revision petition
Mm.
preferred by the present petitioner. By
And
setting aside
remanded the matter to the trial court.
my lord.
Thereafter remanded the matter to the trial court.
Yes, my lord.
Hmm.
After remand, the defendant again file a petition
Mm.
that they may be allowed to amend the written statement.
Mm. No, you come to the last part of the order,
Yes.
paragraph number 15.
Well, according to the Learned Trial Court below, the Learned Court held that no issues were framed. Your Honor. But Learned Trial Court below already decided the preliminary issues.
Mm.
This is the
No,
crux of the-
thereafter, the same was set aside. Finding of the trial court was set aside.
already the order was set aside by the by your lordship in the criminal division petition
Mm.
filed earlier.
Mm.
Subsequently, they have filed this petition and order was passed subsequently.
No, you come to paragraph number 15 of the impugned order.
Yes. In the instant case,
Mm.
the plaintiff has filed a suit
Mm.
for declaration of right title, interest
Mm.
and for permanent injunction. The
Mm.
defendant has opposed by filing written statement. The trial court of this of the suit has not subsequently proceeded. Issues are yet to be framed, but but according to the order passed by the Learned Trial Court below, the preliminary issues are already decided.
No, that order was set aside.
But issues here framed, but Learned Trial Court below come to a finding that Learned Trial Court has no jurisdiction to try this.
No, thereafter the matter was remanded to the trial court.
Trial court.
And after remand, the Learned Trial Court had not framed any issue.
My lord, Learned Trial Court below, as the Learned Trial Court below has already framed issues, there, so the Learned Trial Court has the jurisdiction to frame additional issues.
Hmm.
It does not mean that the Learned Trial Court below did not frame issue.
No, that order was set aside.
Or the issues were not set aside.
No,
but
once the order is set aside, the issues are also set aside.
Impugned order was, my lord, that the Learned Trial Court below has no jurisdiction. That point was decided by the Honorable High Court in our favor. That does not mean that the suit will not consider by the Learned Trial Court below.
Mm.
We have the next step is to adduce evidence or SBPS, will not. So if that is
No,
done
you
by
come
the
to this
Learned Trial Court,
paragraph number 15 of the impugned order.
my lord. Issues are yet to be framed, but
Hmm.
issues are decided. Additional issue may be framed, there is no bar, Your Honor. The trial court, even the first appellate court can frame the issue and remand the case. There is
Okay,
no bar.
okay, we will issue notice then. Third, Mr., your good name, please. Your name, please.
PP does, my lord.
Learned Counsel for the petition. This petition under Article 227 of the Constitution of India is referred by the petitioner, namely Sri Khoghen Das, challenging the correctness or otherwise of the order dated 31/7/2024 passed by the learned Civil Judge Junior Division Nalbari in title suit number 155 of 2021. Full stop. It is to be noted here that by the impugn order dated so and so, the learned Civil Judge Junior Division Nalbari has allowed stroke accepted additional WS counterclaim filed by the defendant stroke respondent. Whereas the petition and the grounds mentioned therein, and also whereas the impugned order dated 31/7/2024, let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Place the matter after 4 weeks, still returnable debt, impugned order dated so and so stands state. Further proceeding of title suit number 155 of 2021 stands state. List after 4 weeks.
My lord, till then, my, yes.
File number 2.
Made clear. Your Lordship,
Yes.
a deed sheet was executed between the petitioner and respondent hearing. And challenging the violation of the lease deed, the respondent had filed a plaint. Thereafter, the petitioner hearing as the defendant has filed a section.
Oh, is there any arbitration clause in
Yes,
the
yes.
agreement?
Yes, there was an arbitration clause. So we had.
But the
filed-
question is that you have not enclosed that agreement.
No,
Either
we-
certificate copy or the original copy before the trial court.
Yes, Your Lordship. What has happened, the plaintiff had filed the lease deed themselves, they had produced the plaint containing the arbitration clause in their plaint. So
Hmm.
it was before the trial court.
Hmm.
We had filed a section 8 attaching the Xerox copy of that agreement. So it
Hmm.
was there. And the objection of the plaintiff that is in the application was no, they had not disputed the arbitration clause.
Hmm.
The only thing is that 8(1) is not complied with. Your Lordship has yourself have passed a judgment here relying on the Punjab High Court judgment. If the arbitration agreement is produced by the other side,
Hmm.
is not in dispute, then the technicality of 8(1) need not be gone into. And the matter ought to be referred to arbitration without insisting for a certified.
Where is that judgment?
Yes. I'll just read a portion of the Punjab Haryana which your Lordship had relied. Then I will go to our own High Court judgment. Punjab High Court is Parampal Singh and others, the Lordship. At paragraph 2, next page. The first contention of the learned counsel for the appellants is that a certified copy of the arbitration agreement was not produced by the respondent along with the application for referring the matter to the arbitrator. Then there were submission here, Lordship may turn to then paragraph 3.
That order is that agreement is
The impugn
page
order,
number.
the impugn order is page 216. The finding is, your Lordship, 217. There are two grounds on which they have rejected the section 8 petition. 217. Last paragraph. So in the instance suit, it can be seen that the defendant had already filed a written statement and it was only after filing a written statement that they filed a for. This is factually incorrect, your Lordship. We had filed our section 8 petition along with WS. And there are numerous judicial judgments or I produce before
Hmm.
Lordship. When the both are filed simultaneously, it does not mean it is later than. It is only after submission of the WS Thereafter, on a subsequent date, if you file a section 8 petition, then the bars trips in. If we file the WS as well as a section 8 petition simultaneously, then it is regarded as before filing of notice, not later than that.
Hmm.
So this finding, and factually it is wrong, not later than it is, we had filed it simultaneously. There's a woman in our CRP also that we had filed it on 27/9/22, both the petition. WS as you were saying. And on the second ground of rejection is not producing the certified copy.
Hmm.
So these two grounds, I feel my humble submission is they are not tenable in law. And the learned trial court ought to have referred it to arbitration in view of the arbitration clause existing in the lease deed. Because the entire case is on the violation of the lease deed, which contains the arbitration clause. The other judgment where it says if the WS and the section 8 petition are filed simultaneously,
Paragraph number?
this I'm sending, this is a J&K High Court judgment. Para 12. May I read your words?
Hmm.
On the bird's eye view of the above produced provision, it becomes clear that the application could not be made later than the point of time when first statement on the substance of the dispute is submitted. The bold distinction between section 34 of the Arbitration Act 2002 and section 8 of the Act is vivid. Under section 34 of the Arbitration Act, an application for reference of the matter to arbitration could be filed only before filing a written statement or taking any other steps in the proceeding. Under that Act, even seeking an adjournment for filing a written statement would be taken to be a step towards a proceeding. Therefore, before doing anything, a party has to apply for reference to a dispute with the arbitration. Under section 8 of the Act, this present Act, the position has been tremendously relaxed. The expression not later than when submitting his first statement on the substance of the dispute signifies that the application under section 8 can be made simultaneously with filing of the first statement. Had the intention of the legislature been same as was working at the time of framing of section 34 of the Arbitration Act, then the wording would have been altogether different. Therefore, in a case where the first statement and the application in terms of section 8 are simultaneously filed, it cannot be said that the application had been filed at a proper state envisaged by section 8 software. So my humble submission is that
So
since
where is your petition?
my paragraph 3 I have stated,
No, where is your petition?
my petition of section 8 is at page 58. Your Lordship. Paragraph 11 and 12, page 63, I have specifically stated. 10, 11, 12. Page 63. That in paragraph 23 of the said lease deed provides that any dispute or claims between the parties arising out of or relating in this agreement shall be referred to arbitration of the sole arbitrator in accordance with 10, 11 and 12 are also same effect. And your Lordship, in fact, at page 60, paragraph 16, next page, we had sought
So you were referring to page number?
63, paragraph 10, 11, 12.
And
And next page, paragraph 16, in fact, we had sought for leave to produce the original at the appropriate time. And as an interim prayer, we had prayed for to keep the main suit in abeyance till this application was heard. So though we have filed the WS on the same day, it does not mean we are submitting to the jurisdiction of the court. Because we have also filed section 8 petition, praying the court to keep in abeyance the further proceeding of the court.
is there any judgment of Supreme Court on this point?
That I will have to, I'll go through, but since I found the Jammu and Kashmir High Court, because filing simultaneously would not mean that I have waived my right of referring the dispute to arbitration and submitting to the jurisdiction of the court.
Heard Mr. R. Sharma, Learned Counsel for the petitioner. This petition under Article 227 of the Constitution of India, reduced Section 151 of the Code of Civil Procedure, is preferred against the judgment and against the order dated 6/3/2024 passed by the Learned Civil Judge Senior Division Boingao in petition number 3206 of 2022. While under Section 5 and 8 of the Arbitration and Conciliation Act 1996 by the defendant in title suit number 98 of 2022. Is to be noted added by the impugned order dated so and so, the Learned Civil Judge Senior Division Boingao has rejected the pair of the defendant, which implicate the petitioner herein for dismissing or returning the instant title, returning the title suit number. What is the number of the title suit?
Titles,
98 of 2022.
yes.
Or returning the title suit and to refer the matter for arbitration under Arbitration and Conciliation Act 1996. Peruse the petition and the documents placed on the record. And also peruse the judgments of JK High Court, Jammu and Kashmir High Court in Ajit Singh, etc. versus Sri Mata Vaishno Devi Shrine Board, Katra, reported in 2001 SCC Online, JNK 17, and Parampal Singh and others versus Punjab State Warehousing Corporation and another.
This has been relied by your lordship.
Citation, I hear citation is
This has been relied by your lordship in a Guwahati High Court judgment at citation.
in the FAO number 2388 of 1998 and also of this court in International Air Transport Association versus Indrani Air Travels Private Limited and another reported in 2022 6 GLT 878. Having considered the submission of learned advocate for the petitioner, this court is inclined to issue notice to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks till returnable date. Further proceeding of title suit number 98 of 2022 pending before the Court of Learned Civil Judge Senior Division, Boingao, stands. Shall be kept in abeyance.
Much of that.
Item number 3.
Lordship, this instant revision application, interim application has been preferred by the defendants petitioners. Challenging the order dated 8/2/2024 as well as 26/7/2024. Wherein in 8/2 we are barred to give evidence. 8/2/2024 at page 58-59. Defendant says prayed for adjournment by petition number 439/24 during the citing the severe health problem of defendant Ghanshyam Talukdar. No medical document was submitted. None appeared for to move the petition. Cost imposed on the last date is not paid. And also defendants were directed to file evidence today without fail. Ground shown is not satisfactory. Considering all this aspect, petition stands rejected. My presupposition is that the person whose name has been given as Ghanshyam Talukdar, you could not come. Therefore, question of producing medical certificate does not arise. One. Subsequently, we filed another petition praying for impleading a person Kulendra Deka, who subsequently he becomes secretary of Nagaon Raj Committee. The new persons.
where implement was allowed. But as per procedure order 1 rule 10 subsection 2, when one person is implemented, therefore the question of filing written statement automatically arises. He was not allowed to file his written statement, nor he was allowed to produce evidence. Therefore, my submission before this honorable court, the 26 7 2024 is a bad. In this petition, we prayed for two prayer was there. One was that we should be allowed to produce evidence, and we should be allowed to implement. One part implement was allowed without allowing us to file our written statements, the newly implemented persons. And second part, to lead evidence, that was closed. It speaks for a argument.
Lead evidence by
Lordship,
respondent number 2. The newly
newly
implemented
implemented
respondent.
person is petitioner number 2, Kulendra Deka. The Kulendra Deka's name has been wrongly shown as a Kalindra Deka. Kalindra Deka and Kulendra Deka, father's name is different. They are two different persons. Earlier, defendant number 6 and 7, Ghanshyam Talukdar and this Kalindra Deka, they were two persons. Hello, Kunindra Sharma and Kalindra Deka, they are two persons. Kunin Sharma was added as a defendant number 1. And instead of putting the Kulendra Deka, Kalindra Deka name was shown as a defendant number 2, but his name was stuck off. So my submission is that when defendant number 2, Kulendra Deka is added as implemented as parties to the suit, as for order CBC, as for order 1, rule 10, subsection 2. Where it is provision, where the defendant is added, plain to be amended. Where a defendant is added, the plain shall, unless the court otherwise directs, be amended. Where even after we did not court allow, the amendment was not allowed, we are not worried also amendment. In such cases, matter may be necessary to amended a copies of summons to the plain shall be served upon the new defendant, and the court shall sink and the original defendant. So here in this case, the moment the copy, we have to serve the copies, amendment copies of the plain. So that case was not there. So therefore, my submission before this honorable court, the defendant number, petitioner number 2, who is added as the defendant number 2, kindly may be directed to produce service of notice to him, summons to him, so that he can file his written statements. And thereafter, the court let the matter proceed.
Okay, let notice go at this exercise.
Lordship.
Let notice go at this exercise.
Lord, notice it till that time judgment is fixed for argument on 24/9. So there till that time, till returnable the matter may kindly be.
Heard Mr. D.K. Bhagavati, learned counsel for the petitioner. Five petitioners, namely Gunendra Sharma, alias Gunin Sharma, Kulendra Deka, Dinesh Pathak, Pradeep Das, and Kalindra Deka, approached this court, being aggrieved by the order dated 8/2/2024 and 26/7/2024, passed by the learned civil judge, Junior Division number 1, Borpeta Ini.
Yes.
Mistake case number
2070.
107 of 2024, arising out of title suit number 60 of 2017. It is to be noted here that by the impugn order dated 8/2/2024, the learned trial court has rejected the adjournment petition filed by the defendants, filed by the petitioners, to file their witnesses on the ground of absence of medical certificate, and thereby close the evidence of the defendants and fix the matter for argument. And by the impugned order dated 26/7/2024, the learned trial court has allowed the petition filed by the petitioners for impleasment of Sri Gunendra Sarma
Deka.
and Kulendra Deka as defendant number 1 and 2 respectively, but rejected the pair for adducing the evidence by the newly impleaded defendants. And also erroneously struck of the name of defendant number 7, Kalindra Deka, confusing the same with the newly impleaded defendant number 2, Kulendra Deka. And also the learned trial court refused to grant opportunity to the newly impleaded defendant number 2, Kulendra Deka, to file his written statement. Having heard the submission of Mr. Bhagavate, learned counsel for the petitioner, I have gone through the petition and the documents placed on record and also perused the impugned orders dated 8/2/2024 and 26/7/2024. Let notice be issued to the respondents
Number 1, sole respondent.
respondent number 1 by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Mr. Bhagavati submits that the next date has been fixed for hearing argument,
On
and
24/9.
unless the proceeding, when it is fixed,
24/9. 2/4/9. 24 September.
24/9/2024. And unless unless the further proceeding is stayed, this petition would be infructuous, and therefore Mr. Bhagavati contended to stay further proceeding of the title suit number 60 of 2017 till returnable that there is accordingly allowed. List the matter after 4 weeks.
Matter number 4.
Operation need to stand state.
Lordship,
No, further proceeding operation.
please, Lordship, the matter may be passed on for timing, senior is in court
Who
number
is
5.
your senior?
After some time, is in lakes of court number 5, Lordship.
Item for admission 6 and 7. Pass over for the timing matter.
May please, your lordship. Lordship, in this matter, we need 4 weeks time to file our affidavit, lordship. I'm appearing for respondent number 5, lordship.
Yes.
Pass over for the timing matter. BJP will lead on the matter.
Who is appearing? Who is appearing?
BJP will complain.
So let them file affidavit then.
Matter.
Heard, Mr. Your good name?
N. Burua.
Learned counsel for the petitioner, and Miss
P. Sharma, lordship, for respondent number 5.
learned counsel for the respondent number 5, and Mr. P. Soikia, learned counsel for the respondent number
I'm appearing for 6. Respondent number 6.
6.
6.
Respondent number 6, and
Yeah, now be the first one, number 1 and 2.
respondent number 1 and 2, and Madam
4.
4. Ms. Sharma, learned counsel for the respondent number
I am appearing for 1, 2, and 3.
1, 2, and 3. Okay. Submits that she may be granted.
4 weeks time, lordship.
Why 4 weeks? 2 weeks?
Lordship, 3 weeks and lordship.
3 weeks. Price for granting her 4 weeks time to file counter affidavit. Pair is accordingly allowed. Recessal is the matter after 3 weeks.
Much obliged.
Number 14.
7, 20.
6 and 7. Regular. Item 14.
May I please, Lordship? My lord, this matter pertains to my lord non-payment of my lord pension, my lord. My lord, this my lord petitioner, my lord, was superannuated my lord, from service from 29 to 2020, my lord. Hereafter, my lord, Director of Secondary Education, my lord, sanctioned my lord pensionary benefit, my lord. And again, my lord, by PPO, my lord, the Director of Pension, my lord, on 21/8/2023, addressed to Treasury Officer, my lord, granted my lord pension, my lord, to this person, my lord. And thereafter, my lord, DDO, my lord, non-royal and non-royal certificate is required from the my lord Inspector of School and my lord Principal, my lord.
Hmm.
But that has not been issued till date, my
With the appearance completed. Service completed,
my lord. Private party, my lord.
private party.
No private party, my lord.
Yes, are you appearing in this
Instruction,
case?
my lord, was
I'm
got from
appealing for accountant general.
Pardon?
Secondary education is the mandate.
You are for?
Accountant general.
Okay.
instruction was got from-
State of Assam, yeah. Hmm. Yes, secondary education, anybody? Oh, secondary education? Director secondary education?
Education, please.
Lordship, talk for some time, Lordship, there are another council for secondary education.
Hmm. And who is for the respondent number 5 and 6? The inspector is school and principal,
For inspector of school, Lordship, secondary education,
secondary education.
Lordship.
Who is?
Item
Pension matter to know.
Item 14.
Oh,
Mention some-
pension or
Pension,
no? Lordship, yet you receive the instructions, Lordship. Oh,
No,
Okay.
are you representing this 5 and 6?
I don't represent 5 and 6. Yes, Lordship, 1, 2 and 5, your Lordship.
So this pair in this petition is for issuing direction to issue, no, to issue non-royal, non-royal certificate. Why don't you issue it?
My lord, royal and non-royal certificate that will be issued by the concerned head of the institute, my lord, where petitioner is working, my lord.
Yes,
Yeah, my lord,
the principal and the school of inspector,
My lord,
inspector of school.
but my lord, that have to be cleared after the closing the entire account, my lord, liability account, my lord.
Pardon?
They have to issue the royal and non-royal certificate by concluding the entire account with that period of his service, my lord. If he has some liability towards the school, my lord, then normally they are not issuing royal certificate. Right, I did.
Is there any liability on his part?
That part probably, my lord, there isn't. Probably there isn't liability, otherwise, my lord.
regarding that, my lord, an affidavit should be filed. And affidavit should be filed regarding that, my lord.
That respondent 6 appeals.
So is there any liability?
I have
No.
no instruction on that, my lord.
Otherwise, my lord, the principal, his presence will be required, my lord.
Principal
Principal's presence will be required, my lord.
presence.
My lord,
Let him also remain present. Next Monday.
my lord.
My lord.
Heard Mr. Sigdar, learned counsel for the petitioner, and Mr. P. Soikia, learned counsel for the learned
And for the
standing
pension
counsel
department.
for
Pension department.
pension
Pension
department.
department.
Respondent number 3. Mr. Soikia,
My lord,
you are for respondent number 3,
3 million.
and Madam Terangpi for respondent number
1, 2 and 5, your Lordship.
1, 2, 5 and 6.
Not 6, your lordship, only 5. 1, 2 and 5.
Who will represent principal?
Principal, my lord, notice have to go.
No,
my lord.
notice have to.
My lord, principal, my lord, IS is the, my lord, in-source principal of that institution, my lord.
IS.
IS, Inspector of School is the in-source principal, my lord.
One district, come well.
Lordship, can you maybe allow 5 minutes so that I'll obtain the instructions, your lordship.
5 minutes.
Yes, your lordship.
Okay.
I'm for
5 minutes. After 5 minutes, let her obtain instruction. Mary, you are appearing in this one.
Respondent 4 minutes.
Respondent number
4 minutes. Accountant.
AZ.
Yeah.
Okay, Mr. Mary, for respondent number 4. AZ. After 5 minutes.
Item 15.
My lord, today the matter was fixed to allowing me to seek instructions over the letter which has been produced by my learned friend on the last occasion. Now, if your lordship would kindly come to, this is annexure 9, page 59, 56. Annexure 9, page 56. Now, my prayer is, my lord, as per the last round of litigation, this court has directed to the authorities to provide us with the my lord, the grant of past services, benefit of past services for the purpose of pension. My lord. Now, pursuant to the last round of litigation's order, my lord, the secretary at page 55, the secretary has granted the approval, page 55. Roshi will see the approval has been granted and the director has been issued a communication. In inviting a reference to a letter on the subject cited above, I am directed to state that the government in the Department of School Education is pleased to accord approval towards the proposal regarding counting of past services for the purpose of computation of pensionary benefits only and allowing pension and other retirement benefits under Assam Pension. I am number 3, Nuruddin Ahmed, and also the second petitioner is number 6, Mehboob Hussain. Now, after this approval, my lord, the director has passed an order, which was placed before your lordship by my learned friend on the last occasion. That is page 56. Now, the director has allowed, and on page 57, the director has also issued a communication to the accountant general to provide me with all the benefits, my lord. Now, pursuant to that, what has happened is on page 58 and 59, for both the petitioners, only the GPF benefit has been granted by the, only the GPF benefit has been granted by the General Provident Fund, my lord, after the direction from the director. Now, my case is that the remaining part of the retirement benefits, especially the increments from my date of joining, which has been reflected in this particular GPF order, my lord. Date of joining, one, the petitioner is 1987 and the other is 1991. Now, those benefits are left behind and it has not been provided till date. Now, since my learned friend has already produced the communication, which I have annexed at page 56, which shows the approval and the direction from the director. Now, my simple prayer is, my lord, if mandamus is issued to the director to complete the process. Otherwise, only the GPF benefit is granted and they are simply sitting over it. Nothing has been done. Let them complete the process of payment of the remaining retirement benefits within a period of 3 months or 4 months. No objection. That is so.
They are still working, no?
They are working. Both of them are still working. Both of them are still working.
Pardon?
Both of them are still serving, madam. Not retired.
Presently.
Yes.
So what are the other service benefits?
My lord, I being an employee, my lord, I might not be aware of all the components, but the instruction for my from the petitioners is that especially it's regarding the increments from my date of joining. Incremental benefits from my date of joining.
What I have been instructed is that, especially the incremental benefits from my date of joining. That has not been provided, only the GPF.
Incremental benefit from the date of joining. Whether that was provided in the order and by the order of this court.
And the approval is also there, my lord, from the secretary. I've
Uh,
taken your lordship to page 55, which is the approval. It specifically says, my lord, computation of counting of past services for the purpose, third line, your lordship will see at page 55. Regarding counting of past services for the purpose of computation of pensionary benefits only and allowing pension and other retirement benefits. So only the GPF has been given by the after the direction of the director.
No, where is the order for granting you this incremental benefit?
My lord, under this component, other retirement benefits, my lord, this will also fall.
No, you were submitting that there is direction for incremental benefit also. Where is that?
Then I have to take your lordship to the order of this honorable court. The last round of litigation. So it starts at page 49, my lord. And the relevant portion. Relevant portion is at page 53, my lord. Para 5. Before this court, the common thread in all the aforesaid 10 writ petition involves that the issue as to whether the provisions of the Assam Services Pension Rules or the newly defined Contribution Pension Scheme 2009 would govern the case of the petitioners. Pertinent to say that the present writ petitioner are not the first kind to address on the aforesaid point of determination. On similar facts, this court has decided by judgment and order dated 28/4/2015 in WPC so-and-so, and in another bunch of writ petitions, the lead case being so-and-so, to say that the service of the petitioners therein are to be counted as per the provisions under the Assam Services Pension Rules 1969, and the benefit of the past services should be counted for the purpose of computation of pensionary benefits as per the said rules 1969. While rendering the decision, this court took into consideration the judgment and order dated 1/9/2003, passed in the very first bunch of writ petitions, the leading case being civil rule so-and-so, which attained final release. In the said judgment and order dated 1/9/2003 and at paragraph 4 thereof, this court recorded the stand of the state government in the following. Furthermore, in the affidavit filed, the state, while stating that the regulation when made to be prospective, has agreed to give the benefit of previous service rendered for the purpose of pension and retirement dues. As the issue of determination have already received due consideration to this court, the present writ petitions do not require reiteration on the same issue, save and except to hold that in consonance with judicial discipline, similar order is required to be passed in favor of the writ petitioners herein. Accordingly, the writ petition stands allowed by directing the state respondents to desist from acting on the undertaking given by the writ petitioners and to count the benefits of past services of all the petitioners for the purpose of pensionary benefits as per the provisions under the Assam Services Pension Rules 1969. Now, my lord, before parting with the present matters, this court would record a submission made by N. Sharma to the effect that decision in the present bunch of cases be deferred as the state respondents have filed review petition so-and-so seeking modification review of the order dated so-and-so. This is the first case deciding on the issue as to whether the Assam Services Pension Rules 1969 or the new defined Contribution Pension Scheme 2009 would govern the condition of employment of the petitioners towards entitlement to pension and pensionary benefits. It is also stated that as on the date the said review petition is yet to come up for consideration before the appropriate court. In the opinion of this court, mere filing of review petition cannot stall adjudication of the present writ petitions. Needless to say, order passed in the review petition would have its natural consequences on the various orders passed by this court, which had been decided following the decision in the said writ petition. There is yet another issue which has been brought to notice to the writ petitioners, in that on the entitlement of pensionary benefits under the provisions of Assam Services Pension Rules 1969 to persons similarly situated, the government of Assam in the Education Elementary Department have last ordered deciding not to insist upon the undertaking mentioned in the appointment and regulation order. This and similar orders furnished to the councils representing the petitioners reflects compliance of earlier orders passed by this court to grant benefits of past services to persons similarly situated under provisions of Assam Services Section rules. Now, my lord, this court has held that I am entitled to all the benefits from my date of joining, irrespective of the undertaking and all. Now,
No, that is only for the pensionary benefits.
now, GPF is not the end of the issue, my lord. There are other components also. And I, being the employee currently serving, will not be able to specifically state as to what are the components, my lord. That is for my employer to present, my lord. Whether only GPF is the end of it or there are other components also. And my instruction is that the benefit of the incremental benefits has not been granted from my date of join.
No, is it granted in this order?
Manoj, the secretary and the director both have stated pension and other retirement benefits. So only GPF will not be mine. There are other components.
Yeah,
also.
that's all right. Some other benefits are there, but you are to apprise the court that these are the benefits I am entitled to.
The difficulty is, my lord, since they are serving teachers and
Yes, madam.
Lordship, I will file my affidavit, Lordship. I will file my affidavit.
When?
2 weeks, Lordship.
You have not filed affidavit till date.
No, Lordship. Weeks time may be given to file my affidavit.
No, you see what are the benefits granted by this court in the order dated 5/2/2019.
Okay.
the court stated all the benefits as per the rules. So that
No, that is there, but it is only for the purpose of pensionary benefits.
yes. The moment the increments are counted similar to those teachers or my colleagues from the date of joining, there will be an impact on my pension also.
You see, in paragraph number 5, it is provided that in the middle portion,
My lord.
is Assam Service Pension Rule 1969.
Yes.
And the benefits of their past services should be counted for the purpose of computation of pensionary benefit.
I agree, my lord. I'm not asking for any money.
Hmm.
What I'm saying is that there are regular teachers whose case is not similar to me. Now those are getting those benefits. Those teachers are getting the benefits from their date of joining. Now, what happened in this particular last round of litigations is that my undertaking was given a go by, and the authorities were directed to grant me the benefits from my date of joining. Now, that doesn't include salary or anything. But the moment the increments come into play from my date of joining, tomorrow my pension might get increased. There will be an impact on my pension. And that is all which has been directed and approved also by the secretary. And the director has also passed an order. But only the GPF benefit has been done.
So, going by this order, It cannot be said that you have given the benefit of this incremental benefit.
Yes,
Hmm.
it's not specifically stated.
And order dated 16 June 2023 of
Yes.
the Director Elementary Education. It indicates that past services of the following assistant teachers are hereby allowed for the purpose of competition towards pensionary benefits only.
Yes. So I have missed the bus
So
for,
you will get the benefits only after retirements.
my lord, that is my case. I do not want it now, my lord. But the thing is, it has not been allowed. Only the GPF account has been opened
Hmm.
from my date of joining.
Hmm.
Whereas there is no order, no whisper regarding the increments. That is all.
Yes, Madam Kaur, you obtain instruction.
Lordship,
We'll fix it on Tuesday.
yes, affidavit, I will file affidavit, Lordship.
No, not necessary, I think, because there is a order of this court dated 5/2/2019. So you were to ensure
On 20th, Lordship. 20
20.
September, Lordship,
20.
Lordship.
Okay. As prayed for by Ms. Kumar, learned counsel for the standing counsel for the secondary education,
Elementary, Lordship.
elementary education, director elementary education and
Elementary education, Lordship.
elementary education, and who are for the rest of the respondents?
Finance.
Mr. Soikia, you are?
Account. Yeah, right.
Respondent 5 is the AG and the respondent 2 is the finance part. Rest are elementary.
And 3 and.
My lord,
24 and
for
6.
respondent number 5, my lord, may be reported the SPM. I'll inform you.
Acha. You give the name of the council. List the matter on 20th September.
Lordship.
So as to enable Ms. Moore to obtain necessary instruction from the respondent number.
4, my lord, direct.
Respondent number 4.
If my lord would be pleased to specify in the order whether whether I am entitled for incremental benefits from my date of joining. I think it's
She will,
easier
she
for-
will, she will, because this court cannot go beyond the order passed earlier.
God bless.
Madam 14.
My lord, we received the inspection just now from the content inspector, my lord. He
Yes.
has liability towards the school, my lord.
Pardon?
He has liability towards the school, my lord.
What kind of
Therefore, my lord,
liability?
non-dual certificate has been issued, my lord.
What kind of liability?
We have to deposit some amount, my lord.
I did.
Some calculation have been given, my lord. It is not clear, my lord. Even he have to return some document also, my lord.
Pardon?
Therefore, my lord, he has called for a meeting, my lord.
Call for?
Call for a meeting, my lord. Amount not written, my lord.
Lord, and if it should be filed, my lord, we will file reply because my lord, I have instruction, my lord, no liability is there, my.
No liability.
Yes, my lord. So we'll file, my lord, reply, my lord, if they file affidavit.
66,000 month. Additional কিবা কিবি আছে total 22 এগুলো কিবা এটা হুম।
2012 to 2020 আছে তাই। এখন 70% বাচ্চাদের মাটির সঙ্গে দিতে পারছে।
রীতিমতো মাটিছে SMC ফল করেছে
There is a my lord resolution. Here written as আজি সভায় ডক্টৰ নগেন দাসৰ ওপৰত আইনী ব্যৱস্থা গ্ৰহণৰ পৰামৰ্শ দিয়ে যদিও প্ৰথমতে বিভাগীয় মাননীয় বিদ্যালয় পৰিদৰ্শনসমূহত মহোদয়ক বিষয়টো অৱগত কৰাৰ ব্যৱস্থা গ্ৰহণ কৰিব লাগে বুলি মতামত আগবঢ়ায় লগতে CM ভিজিলেন্স বা এন্টি
Oh, Mr. Soikia, you tell me what is the liability?
While he is discharging the duties as a principal of the school, my lord, he has some liabilities, my lord, regarding their fund, RMSF fund and etc. my lord. Regarding allotment of the government fund, my lord. After utilization of the fund, he have to furnish the details of the fund along with the audit report. Now, 3 years audit
But for that reason, you cannot held up his pensionary benefit.
report. No, my lord, that is the rule of the department, my lord. If it is a public money, my lord. After the
Public money,
there is an
you
internal
recover
audit
it
in the department,
in accordance with law,
my lord, there is a
but you cannot held up pensionary benefit.
no, my lord, there in the education department, there is an auditor appointed by the government, my lord, to audit that account, my lord. Otherwise, PP has already been issued, my lord. His duty to cooperate with the school authority, my lord.
No, but unless and until this non-drawal certificate is issued, he cannot draw any of the amount.
My lord.
When he retired,
My lord, 29 to 2020, my lord.
20, my lord.
And my lord, PPU was issued, my lord, 2023, my lord. Thereafter, my lord, I applied for the, my lord, concerned authority, my lord.
so we are disposing of this writ petition. You issue this certificate, non-drawal certificate within a week from today. And if there is any liability, you recover it in accordance with law.
No, my lord, from pension, we cannot recover, my lord. Because, my lord, he have to be given the deposit first, my lord.
Pardon?
No, pension, we cannot, my lord, recover, my lord.
Yes.
Then he
You
have to
adopt
deposit
any
first
other
because
course
without-
available to you.
without, clears the audit report, my lord. It is the government fund, my lord. Then that have to, after utilization, he have to be given the, that's audit, my lord. Then perhaps petitioner will be not face any difficulties, my lord. Because he have utilized the fund, their fund is a very specific, my lord. Moreover, my lord, apart from that, my lord may direct to the concerned petitioner to appear before the school inspector, inspector of schools, or my lord, alternatively SMDC, my lord. So issue can be resolved, my lord.
Why this is his petition, his peer is to issue direction to issue non-drawal certificate only.
No, my lord, that
Why
is-
should we direct him
that
to
is-
appear
that is-
before
that
you?
is the problem, my lord, because my lord, government fund have to be utilized, my lord.
Hmm.
Even the government official, my lord, they cannot hold the fund, my lord. And if this kind of petition is, my lord, allowed, if this condition is going on, then, my lord, it will be create very hassle in the future, my lord. Because every officer, they will be not given any clearance, my lord. Therefore, department, my lord, has made a specific local auditor, my lord, for this purpose only, my lord.
You do whatever you like, but release his benefits.
Then, my lord, my lord may allow us 4 weeks time so that we can call the petitioner
Why?
to the school, my lord.
No, he has already retired in the year 2020.
That is absolutely true, my lord. Even, my lord,
Till
this
that
also-
he is without any pensionary benefit.
even also, my lord.
How can he will survive?
No, my lord, initially, my lord, provisional grant, my lord.
Hmm.
Provisional pension
has
grant,
not
my
been
lord,
received,
without
my lord.
considering this aspect.
That
my
has
lord.
not been also received, my lord. Provisional, my lord, thereafter, my lord, stopped, my lord. It was stopped.
Hmm. So for this purpose, you cannot held up his pensionary benefits. You take any legal recourse available to you, but release his pensionary benefits and issue non-dual certificate.
No, my lord, it will be create a hassle for the entire department, my lord.
Pardon?
No, it will be create hassle for the entire department, my lord. My lord.
It is your problem.
May I pray, my lord, that since my lord PPO has issued, that pension department has done their part.
Hmm.
Now only regarding that giving the utilization in the audit, my lord. It is the duty
But
of the
that
petitioner
also
also
not
because
been,
my lord, he has only public post.
are you getting the pension now?
No, my lord.
Pension not getting, my lord, because PPO order issued, my lord, due to non-dual
Maybe,
certificate pension.
but unless this non-dual certificate is issued to him, he cannot draw it.
And it is pending since 2023.
Hmm.
Even, my lord, I think if he is forwarded with the SMDC, my lord, he will not face any difficulty, my lord.
Pardon?
If he is forwarded with the SMDC, my lord, or local auditor or the inspector of school, my lord,
Hmm.
he will not face any difficulty, my lord. Because if he is a hustle for the pension, my lord, pension is a requirement, my lord. If something has to be returned to the government, definitely he can return, my lord, because it is not a personal money.
Return, you can deduct it from his entitlement also.
My lord, because my lord, without initiating this proceeding, my lord,
Pardon?
without initiating this proceeding, my lord, we cannot even initiate for the recovery, my lord.
And who is responsible for not initiating the proceeding since 2020?
No, my lord, because issue is that, my lord, pension department has issued the PP order.
Hmm.
That is their obligation they have issued, my lord. And by making certain condition, then you have to deposit the non-dual certificate for utilizing the pension, my lord. They have done their part, my lord. Now, being an headmaster, it is his also duty, my lord.
So we are disposing of this petition. Within 1 week from today, you issue non-dual certificate to him. And
No, my lord,
for
then-
recovery of any other
No, my lord, even
due,
my lord, if the
you can
petitioner,
take
my-
necessary action.
my lord, may I pray something, my lord? If my lord, like kind of petition, if is able to get the order from this honorable court, my lord, then tomorrow, my lord, 1,000 of the headmaster will come this situation, my lord.
Maybe,
And my lord,
maybe. Who is responsible for the same?
no, my lord, he is responsible because non-dual, because giving
No,
the
why,
audit account,
why,
my lord,
why
it is his
you
duty,
have slept over for last 4 years?
my lord.
Why no
No,
action
my,
was
my
taken
lord, we have
for
not
last
taken
4
over
years?
because my lord, as the procedure, my lord, we have issued the PP order, my lord.
Hmm.
That it is not our negligence, my lord. We have issued the
Okay.
whatever is the
Heard
process of the
Mr.
office, my lord.
Sigdar, learned counsel for the petitioner, and also heard Mr. Soikia, learned standing counsel for
No, I am for it, pension department, my lord.
the pension department. And Madam Tirampi, or respondent number,
She is for my lord, 1, 2, 4, 1, 2, and 5, my lord.
1, 2, 5,
1, 2, and 5.
1, 2, and 5. So why can't say represent the principal?
Principal, my
Because
lord,
he is also a government employee.
no, my lord, normally principal, my lord, notice have to go, school authority will appear directly, my lord.
When I filed this petition, my lord, at that time, my lord, inspector of school was in charge of.
But
my
now
lord,
new
principal,
incumbent
principal,
joined,
my
my
lord.
lord.
Newly, my lord, new principal has been appointed.
So principal cannot be a private respondent.
No, yes, ma'am.
No, principal can be a private respondent, my lord.
Why?
Because my lord, this is the provincial.
He is your employee.
No, employee is the government employee, but he is the heading by the provincial school, my lord. We have not taken the entire school, my lord. We have taken only service of the research, my lord. In purely government school, that department can take, my lord. Or otherwise, if my lord may please, my lord may direct the concerned principal, my lord, to appear before the court, my lord, that will be clear everything, my lord. Along with the record, my lord. Within.
No, according to him, principal is not there. This
Along with that, yes,
respondent number 5 is holding the charge of principal.
At that time,
No,
Now it is.
my lord, because-
newly appointed, my lord, new principal, my lord.
my lord, that record will be say everything. He can come with the record, my lord. Within 1 week, my lord, may be listed with a direction to appear by the principal, my lord.
4 years already gone, my lord.
Otherwise, my lord.
When the
consider
new
right
principal
only-
is when the new principal is appointed,
My lord, that instruction, my lord, I have to take, my lord. Recently say this is.
yes.
And normally, my lord, for releasing the pension, we are not insisting for blockage of the pension, my lord. But this situation also we cannot insist that this should be waived, my lord, because.
So, madam, why you cannot represent the principal? Why you cannot represent the principal?
Oh. Lordship, I cannot appear for the principal, your lordship.
Pardon?
I cannot appear for the principal, your lordship.
Why?
Provincialized school.
He is not a government servant.
It's a provincialized school, your lordship. Hmm. তিনিবাৰ চাৰিবাৰ টেলিফোন তেওঁ নাই আহা। Lordship, here the petitioner was called for an SMC meeting 4 times, 5 times, but he didn't appear, your lordship.
No, you cannot bargain with his pensionary benefits. It is his fundamental right to get pensionary benefit.
Should be clean. এই কথাটো লাগিব।
Now, my lord may give us as an opportunity to call the principal and along with the record, my lord. Then my lord may fix after 1 week, my lord.
After?
After 1 week, my lord,
For what purpose?
for calling the records of the entire, my lord.
So this As per order dated 29/4/2024, service completed upon respondent number 6. So let us fix it on Tuesday. In the meantime, you obtain necessary instruction. We keep it as parted. List the matter on Tuesday as parted. In the meantime, the learned counsel for the respondent number 1, 2, and
2 and 5, Lordship.
1, 2, and 5 shall obtain necessary instruction.
16 and 17.
But in this case, my lord, the petitioner is already covered by my similar order, my lord, page 56. What happened when the issue in this case is that the petitioner pursues his B.Ed degree, my lord, without obtaining NOC, which is from the department, my lord, from the inspector of schools, and he has completed the degree, my lord. And that's the reason, my lord, for that he has not been given the charge of the principal, in spite of he is the senior most teacher of the school, my lord. And the junior one, my lord, given the charge initially, that was subsequently staged by this honorable court. And my lord, in this regard, the issue of this honorable court has decided already, and at page 49, my lord. Operative portion, my lord, I take the lordship to page 54. That was in respect of another case. The MA degree acquired by the petitioner having so acquired from a recognized university, the said degree is otherwise valid and acceptable in law. And accordingly, the petitioner having fulfilled the eligibility criteria as mentioned for recruitment to the post of principal of the school in question, under the provisions of Rule 12(3) of the said rules of 2018, a legal right has accrued to the petitioner to hold the charge of the post of principal of such and such school. Accordingly, the matter stands remanded back to the Director of Secondary Education Department, who shall now pass appropriate orders allowing the petitioner to hold the charge of the post of principal such and such school after due verification of the particulars of all the candidates in fray. It is needless to say that the Director of Secondary Education, while considering the qualifications of the eligible persons, shall be at liberty to examine as to whether the said qualifications were obtained from the recognized universities or institutions. The exercise required to be carried out to allow the petitioner to hold the charge of the post of principal of the school shall be carried out by the Director of Secondary Education within a period of 2 months from the date of receipt of the certified copy of this order. And my lord, the Supreme Court, Honorable Supreme Court has also in many judgments, my lord, has decided this issue. I have annexed one judgment, my lord, at page 61. It is not 61, it's 50, it starts from 59. It is the judgment of the Honorable Allahabad High Court, my lord, where the judgments of the Honorable Supreme Courts have been quoted, exactly similar issue, my lord. I'm reading, my lord, paragraph 5. The submission of learned counsel for the petitioner such and such is that the petitioner was the senior most teacher who was eligible for being promoted as lecturer at the relevant point of time. The claim of the petitioner was rejected solely on the ground that the petitioner obtained the MA Political Science degree in the year 2010 without obtaining permission from the competent authority. The denial of the promotion is arbitrary and contrary to the government order dated such and such, and the law laid down by the this honorable court in such and such case that the petitioner is entitled to full back wage as back wage of the promotional post. Learned counsel for the petitioner refers to the authorities
to his entitlement of to full back wages. I'm reading, my lord, paragraph 16, page 61. The next question is whether the failure to take permission from the manager of the institution would invalidate the effect of such decree. The question in a similar factual matrix was posed to a division bench of this court. In this case of Dr. Such and such, in the case of Dr. Such and such Supra, the petitioner had obtained the M.Ed degree as a regular student without taking leave from the college where she was working as a teacher. It was contended that M.Ed degree could not be considered for the purpose of promotion. A stand to this effect was also taken by the Committee of Management before this court, negating the stand taken by the Committee of Management. This court held, in our opinion, M.Ed degree obtained by the petitioner cannot be overlooked merely on the ground that the said degree was obtained without taking leave from the college where he was working. We are unable to subscribe to the view taken by the learned judge in the case of such and such. A degree obtained by a candidate from a recognized institution cannot be ignored merely on the ground that the candidate, who was also a teacher in the college, had not taken leave. In such circumstances, it cannot be said that the petitioner of the respondent 1 did not possess the requisite qualification for being considered for promotion to the post of lecturer in education in the college. I'm reading paragraph 20. It could be opposite to reinforce the narrative by good authority. The Honorable Supreme Court in the case of state of Maharashtra versus such and such reported in such and such, emphasizing the role of a teacher as a role model and the recruitment for continuing education for teachers held thus. The teacher plays pivotal role in molding the career, character, and moral fibers and aptitude for educational excellence in impressive young children. Formal education needs proper equipping of the teachers to meet the challenges of the day, to impart lessons with the latest techniques to students on secular, scientific, and rational outlook. A well-equipped teacher could bring the needed skills and intellectual capabilities to the students in their pursuits. The teacher.
Okay, now you tell me what the rule provides.
My rule provides that a teacher must have the master degree and B.Ed and 17 years of teaching experience as graduate teacher. That I have got, and he must be the senior most teacher of the school. I'm the senior most teacher of the school, having all the requisite qualifications. And in spite of that, I was not given the charge of the principal for not having the NOC in the case of obtaining the B.Ed degree. That is the
no. What is the rule?
The rule says, my lord, that one must have the master degree with the B.Ed and 17 years of teaching experience.
This regarding obtaining this MA degree.
MA degree, my lord, actually, as per rule, my lord, one has to take NOC from the, as per rule 13 of the 1965 Assam Civil Service Contract rules, my lord. Every employee, whoever he may be, for obtaining the higher qualification during his service life, he is required to take the permission. That is the actual.
If the permission is not obtained, NOC is not obtained, then
my lord, since 1977 till 2022, my lord, all the teachers who were not, no teachers were obtained any NOC, my lord. All the teachers for long years, my lord, have been allowed to hold the charge.
We are not concerned with other teachers. What happened to you?
In my case also, my lord, this time they have incorporated this condition that you have to obtain the NOC. And this issue of NOC.
And what is provided in the rule if the permission is not obtained?
Permission is not obtained, the degree will not be invalid, my lord.
Yes, degree will be valid.
Degree will be valid. Degree will be valid, and for that they are not giving the charge of the principal to the teachers concerned. That is also, this honorable court has decided that you cannot restrain. You have to give. You cannot impose such conditions. Honorable Supreme Court has also said, my lord, in many cases that if the degree is obtained merely not because of having the, my lord, NOC, you cannot debar him from the benefits.
Yes. So where is the rule, madam?
Lordship, I have received the instructions, the parawise comment yesterday, Lordship, so kindly grant us some time to file the affidavit, your Lordship.
The date may be fixed, my lord, before vacation.
Third, Mr. Your good name,
B protest.
learned counsel for the petitioner. And Ms. Teran P, learned government advocate for the respondent number.
All respondents, your Lordship.
For the respondents, Ms. Teran P submits that she has received instruction and she will file counter affidavit in this petition. There is accordingly allowed. This is the matter on COVID when
Lordship, on 30 September.
30. 30.
Public.
You kindly the matter be kept for time being. Senior is on legs.
Acha, okay.
Obliged.
Item number 18 and 19.
18 and 19 are Lordship, both are separate cases. First, 18 may be taken up, Lordship.
Pardon?
18 and 19 arising out of different cases.
So different cases. Sir. Take a look at copies.
Item number 18, my lord.
Mhm.
Second application, my lord.
Second or third?
Second, my lord.
Are you sure?
I searched in the internet and also, my lord, take instruction from my client, my lord, and also I take instruction from my client and also search in the internet, my lord. I got only one, my lord, earlier. And about 3.5 years, my lord, is behind.
3.5 years.
About 3.5 years, my lord.
What is the stage of investigation? On the stage of trial?
My lord, on last 4 occasions, my lord, IO, my lord, did not turn out before the learned court.
It is pending for evidence of IO.
IO.
Rest of the witnesses examined.
Yes. As many as 15 witnesses are there, my lord. And 13, no?
Out of 15, 13 already examined, my lord. 13 examined and only 2 remains, my lord. And next date is actually, my lord, last 13/8/24. Up to 13/8/24. After 13/8, we don't know, my lord. As per the LCR, my lord, last date was 13/8/24 for further evidence.
Whether any witness has been examined on that day?
No. That was fixed on 13/8 as per the LCR, my lord. After 13/8, the order of 13/8, we don't know.
Today is 12.
12/9.
12/9.
Almost 1 month, my lord, on that day, and again maybe subsequent to that, my lord, another date may be, my lord, but
No, is it not available in the?
no. IO is, my lord,
Lordship. Then, my lord,
evidence of
not
IO is, my lord, pending, my lord.
then not examined, my lord, today morning.
So
my lord, I think
if it is in the last stage,
And
then whether the witnesses examined till that implicated him.
one PW4, my lord, though police personnel, my lord, fact is that, my lord, one truck is coming, my lord, total 600 kgs of
That's
ganja.
all right, I have remembered it.
Yes, and he is the person who will receive the my lord, consignment, my lord.
No, my lord, I did not receive, my lord, from the FIR itself to
No,
refresh, my lord.
who is supposed to receive? And
Lordship, my lord.
police along with the truck went to that place and he was waiting along with his car. When driver called him, he was waited at that place and with his car, my lord. He is supposed to receive the consignment.
Naka was conducted at, my lord, Silonijan, my lord. And, my lord, I was arrested in, my lord, Rongajan, my lord.
No, not Naka was conducted. It was on the, there was a previous information.
Previous information. And I have phlegma, my lord, PW4, my lord. He specifically.
No, my question is whether the statement of all the witnesses examined so far are available in the case record.
Up to 13, my lord, yes.
13.
Up to PW 13.
And whether they have implicated the present accused.
PW4 specifically implicated, my lord.
PW4.
In the side, there is a flag mark money. Evidence of feasibility for next page, Malad, regarding his part, Malad. Udit Datta. Exactly 2 years, 5 months. Exactly 2 years, 5 months. For 24, 21. And 13.
So have you checked the status of the case in the CIS?
I have not checked. CS, I have not checked.
CIS, my lord, I searched, my lord. But it was up to date, my lord, on 13/8/2024, my lord. But today morning, I took instruction, my lord. But client says, my lord, last 4 occasion, my lord, it was fixed for, my lord, examination of the IO, my lord, but he didn't turn up, my lord. And case is pending for, my lord.
So
for,
some materials are there against him.
And
So at this stage, it would be difficult to grant you bail.
There is, my lord, there is no direct possession, my lord, that is admittedly, my lord.
possession, Malad, it might have, Malad, the statement.
Hmm?
He is
We
supposed to.
argue those points before the trial court. Because we cannot consider it at this stage.
And my lord, period of, my lord, detention, my lord.
Hmm? Length of detention cannot be considered. It is a commercial quantity.
600 kgs of.
Then how do you satisfy the requirement of section 37?
Section 37, my lord,
Hmm.
my lord, so far, my lord, detention is concerned, my lord. I can place you to judgment of Honorable Apex Court, my lord. May I place, my lord? On judgment, my lord. On this, my lord, Ravi Prakash.
Hmm?
first your lord take my lord Ravi Prakash my lord. It's a
Hmm.
division bench judgment my lord 2026 USSC. SC 707 my lord paragraph 4 is relevant my lord. As regards to the twin condition contained in.
But the problem is that in this Ravi Prakash case, no law has been laid down. And before this judgment also there is another judgment of 3 judgments in NCB versus Mohit Agarwal. So in view of that, they say 2 judgments decision cannot be read as a precedent.
My lord, another judgment my lord.
You go and argue the matter before the trial court at the time of argument. Heard Mr. K. Borwell, learned counsel for the accused, and also heard Mr. K. Parasor, learned additional PP for the state respondent. This application under section 4.
439 my lord. All pending case.
413(9) of the Code of Criminal Procedure 1973 and under section 483 of BNSS is preferred by accused Udip Datta, who has been languishing in jail in connection with Khatkoti PS case number 69 of 2021. Under section 20B, Roman 2, capital C, stroke 23C, 27A, and 29 of the NDPS Act. Since 14/4/2021. Pending before the Court of Learned Special Judge Karbi Anglong Difu, for grant of bail. The said case has been registered on the basis of an FIR lodged by SI Midul Rudra Pal of Khatkoti Police Station on 13/4/2021. This pair number 3, page number 33. Mr. Borua, learned counsel for the accused, submits that the accused was arrested on 14/4/2021. Since then, he has been languishing in jail for more than 4 years.
3 years.
3 years, and that investigation and that trial is yet to be completed. And considering the period of detention, Mr. Borua contended that the accused may be enlarged on bail. In support of his submission, Mr. Borua has also referred to a decision of Honorable Supreme Court in the case of Ravi Prakash versus State of Odisha, reported in 2020 0 Supreme SC 707. And also a decision of Honorable Supreme Court in the case of Sariful Islam alias Sarif versus State of West Bengal, reported in 2022 0 SC 0 Supreme SC 1925. Whereas Mr. Parasor learned additional PP submits that the cases at the last stage of trial, and out of 15 witnesses cited in the search sheet, 13 have already been examined, and there remains to examine the IO only. And that the offenses are serious in nature, involving commercial quantity of psychotropic substance. And therefore, Mr. Parasor has contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also perused the scanned copy of the record received from the learned trial court. It appears that the accused was arrested on 14/4/2024, and since then he has been in jail. Further, it appears that altogether 15 witnesses have been cited in the charge sheet, and out of 15 witnesses, 13 have already been examined. And it also appears from the evidence recorded so far that some implications are there against the present accused. Besides, the quantity of contraband substances allegedly recovered from the possession of the accused is a commercial quantity. And as such, the accused has to satisfy the twin requirement of section 37 of the NDPS Act. But from the materials placed on record and also from the submission of learned counsel for the petitioner, this court is unable to derive its satisfaction that the accused is not guilty of the offense and that he will not commit any offense while on bail. Having considered above, this court is of the view that no prima facie case is made out for granting bail to the accused. Accordingly, the petition stands dismissed. However, the learned trial court is requested to expedite the trial and to complete the same as soon as practicable. In terms of this BA stands disposed of.
He is in custody since last 3 years, 5 months.
3 years, 5 months.
Yes. The second bail application, Lordship. Earlier bail application order, your Lordship will find page 55. The same was rejected in the month of January 2024, and since then, Lordship, the trial is still in same stage, has not progressed. And now my case is that, Lordship, nothing was recovered from his possession, Lordship, and coupled with the fact that delay of 1 year, 7 months that he is in custody, that his bail prayer may be considered. Paragraph page 58 of my petition, Lordship, may kindly see. Paragraph 11 of your Lordship's order.
Yes.
Even for the sake of argument, it is accepted that the contraband substance were not recovered from the conscious possession of the present petitioner accused, yet the same does not absolve it of level of scrutiny required under section 37(1) NDPS Act, as held by the Honorable Supreme Court in Nawaz Khan's case recorded in so as the quantity of contraband substance recovered from the cowshed of the house premises of the accused is of commercial quantity, and as such, the embargo under section 37 of the NDPS Act will definitely come into play. But from the materials on record, so these observations were there regarding that other things. And in last paragraph 16, your Lordship directed. However, the learned trial court is directed to complete the trial as expeditiously as possible without being influenced by any of the observations made by this court herein above. And if necessary, the learned court below shall take recourse to provision of section 3091 of the CRPC. But the trial, Lordship, still is at the same stage. And from the FIR, your Lordship will find that page 19, I'm sorry, Lordship, page 8, page 10, Lordship, and relevant portion, page 12. The initial information was from in the house of Asabuddin. Asabuddin is his father. That his father has kept some contraband in his house, and accordingly, police went there and recovered those articles. And after recovery, Lordship, that one line that your Lordship may kindly see, page 13. In middle portion, your Lordship will find the house owner Asabuddin. Lordship, in middle portion, the house owner Asabuddin could not give satisfactory explanation about source of seized drug, and he revealed that his son Farooq Ahmed have recently started peddling of drugs, and he might have Lordship, he might have kept those tablets concealed inside a school bag at his cowshed, and currently he is at Mizoram for some work. So admittedly, he was not there and only on the basis of the statement of co-accused that is Asabuddin, he was implicated, Lordship.
What is this? The case is pending now?
Evidence, Lordship.
Evidence.
state. Lord, I'm just relying on few.
How
orders
many
of
witnesses have been examined till date?
No witness examined till date.
No witness. He's behind the bar for how many days?
1 year, 7 months, 12 days.
1 year?
7 months, 12 days. And there is no criminal antecedent, Lordship. Lordship, may I see that Sinsi Babu case at para 4. It may not, it may be seen from para 6 of the impugn order. Lordship, And the second Lordship, that Naeem Ahmed, Lordship, that paragraph 9. It is a seriously debatable question of fact whether the appellant was also found in the conscious possession of the contraband. But such a question of fact will obviously be determined by the trial court at an appropriate stage. That being so, it seems that to us, that as of now, the twin test of section 37 of the Act need not be invoked against the appellant. So if that, admittedly, he was at Mizoram, it is the statement of co-accused. If anything is there, he will face the trial and prosecution can bring any material during trial. The second Lordship, that Anjannath case, here Lordship, delay was there, that was not considered, this is against our High Court order, Lordship. And considering the length of detention, he was granted bail, Lordship. That length of detention was 1 year, 7 months. And that Alamgir's case, Lordship, that year I am referring to last second paragraph, Lordship, admittedly that paragraph, because Lordship, my case was rejected in the month of January, Lordship, and I am in the month of, we are in the month of September, Lordship, and till that, Lordship, the status is safe. And in this next Mokbul Hussein's case, Lordship, here also against our High Court order, Lordship, that here altogether 3 persons were there. From 2 persons, contraband was recovered. From Mokbul was implicated on the basis of co-accused statement. Other 2 persons were granted default bail, but his bail application was rejected. Then Honorable Apex Court, Lordship, considering the fact that the person from whom contraband was recovered is on bail, and that was not challenged, he was granted bail. And in similar to my case, Lordship, here, Lordship, that Asabuddin is on bail. That bail order is not challenged till date by the state, Lordship. And Hussainur Zaman, that criminal antecedent, that part, Lordship, may I say paragraph 4. That's. And in paragraph 2, last line, your lordship will find that they were in custody for 1 year, 4 months. And the last judgment that Bharat Chaudhary's case, your lordship is aware that here lordship it is said that Tufan Singh is applicable in bail cases also. Only for that purpose I have given. Paragraph 11, lordship may kindly see. So that is my submission to your lordship, that declaring trial and nothing was recovered from his possession. If it is from lordship, whether he has that animus or not, that they can prove during trial, lordship. And after rejection of my earlier bail application also, they got sufficient time for producing their witnesses. But after about 9 months also, they have not produced a single witness, lordship. And I am in custody. Admittedly, nothing was recovered from his person. And whether he has that animus to possess or that will be that come up during trial. And he is local person, there is no chance because the other accused, who is his father, he is regularly appearing. It is not their case that he has absconded or done anything wrong or when a cancellation application is filed. No, nothing that sort of.
But the fact remains that it was recovered from his position, from his house.
No, from the cow shed, not house. It was from cow shed, which is adjacent to his house. At the relevant point, he was at Mizoram.
Maybe.
And
The
father
question
says,
is whether he has a knowledge and intention to possess the same articles, and whether he had control over the said articles.
that
That
can
is
be
the question.
decided during trial. If it is found, he will be convicted. That therefore also I have relied on that judgment of Slash Babu, lordship. Noimuddin judgment, lordship, paragraph 9.
Which one?
Noimuddin judgment, lordship, paragraph 9. Naeem Ahmed. Paragraph 9. Naeem Ahmed. Naeem Ahmed, paragraph 9.
When this was pronounced, 28-2.
28-2.
But prior to this, there is judgment of this Nawaz Khan. Nawaz Khan is of 3 judgments.
Lordship. Nawaz Khan is there. Just lordship may kindly say that here from this.
Can we read this Naeem Ahmed as precedent?
No, that Nawaz Khan is lordship. That is factually some different. Is my humble understanding, lordship, because there was some persons and their lordship leading to discovery was there in that case. And in my case, lordship, that leading to discovery part is not probably there. Because of that reason, there was connection. Because if he say, although he was not in conscious person, but he said that article was there, and accordingly, police went there and police found those articles.
No, facts may be different, but the proposition of law laid down in that case, can we ignore it?
But in that case, section 27 will come. But in my case, 27 is not there. That leading to discovery part. What I am saying is that. That leading to discovery.
Yes, Mr. Parasar.
Yes, Malad has rightly pointed out, Malad, it is recovered from the cow shed house owner is his father. It's not like it is his house, my lord. It is not a house of any XYZ. My lord, maybe the name of the owner of the house is his father. So whether it is not his house, my lord. At that point of time, he was in Mizoram. FIR on, my lord, 18/7/22. Father was apprehended on the same day. And Sasit was on 30th of December 22. But subsequent to that, further investigation was going on. He was apprehended only on 2/2/23. This petitioner apprehended on 2/2/23. And as per his father's evidence, father's statement, that might have, though it is reflected Sasit, that he has kept in the cowshed. And subsequently, during investigation, it came to light that he doing business, he bringing those articles from Mizoram and selling in Assam. That business is going on, and quantity is 30,000 Yaba tablets. Total weight is 3.27 kg. Charges were framed on 5/2/24. Obviously, Malad, there is on 4th occasion, Malad, yes, I have checked in the Malad LCA, Malad, on 18/4/24, 13/5/24, 6/6/24, and 27/4/24. No PWs were absent. 4 occasion. As per last order, this fixed one, Malad, 2/9/24 for evidence. But thing is that, Malad, in one case, Malad, leading to a discovery, that's another thing, Malad. But in the present case, it is his house. House owner is his father. It's not a house of any XYZ. He cannot deny that. Maybe the name of the house owner is father, Malad. It is from his house it is recovered, seized. And as per the statement of father, my son might have. And it is also come to light that he is on Mizoram. After the investigation, it has come to light that he is doing business. He is bringing those articles from Mizoram, selling at Assam. So, Malak, at this stage, Malak, yes, there is on 4 occasions, Malak, that is there, Malak. But
the submission of my learned friend is squarely covered by that judgment which I have given Sinse Babu, Lordship, paragraph 4. That's
Which one?
Sinse Babu. That paragraph 4. That large quantity, section 37, all those things are there. Conscious possession.
Sinse Babu. Paragraph number 2.
4. May I read?
Okay, we'll see. Heard Mr. Ahmed, learned counsel for the accused, and Mr. Porasa, learned additional PG for the said respondent. Argument concluded, order is that.
Obliged.
Item 61.
Maybe the order. This is the second time with application, madam. Your lordship may kindly come to the order, madam. That will pass.
Sir Kotogi, this scan copy of the record has not been received.
Oh, I see, ma'am. Actually, this is the stage of furnishing of documents. Document has not been furnished as on today. Only FIR and Sasit has been furnished.
Mr. Fukon?
Yes, last occasion, my lord, the status report in the LCR was called for. That status report is necessary.
Why the copies are not furnished to him?
My lord is revealed from the status report, my lord, why it's not. Because I also appear in I know only some documents were made, only the FIR and SARCIT has been made in the pen drive.
No, he is entitled to all the documents relied
There were
upon by the
many
prosecution.
accused persons, my lord, there is voluminous in nature, my lord. It's true, my lord.
Office note dated 13/9/2024 indicates that scan copy of the record has not been received from the learned special judge, Assam. Accordingly, it is provided that Registrar shall issue reminder to the learned special judge Assam for transmitting the scan copy of the record without further delay, list the matter on short date
23rd, my lord.
20
This time.
20.
20, yes, they will go. Much obliged.
Number 20.
Yes, Parasar,
My lord, yes. My lord,
has they received?
still received, my lord, yes.
So is there any material against him?
Material, my lord, fact is that this power of attorney was fake. My lord, FSL also proved that, my lord, signature doesn't match, my lord, along with the, my
No,
lord,
that may be, but whether there is any material against the present applicant?
my lord, he was along with the person, but specific, my lord, he was there, but he has signed, I have not found. And one thing is that I must say before this court, my lord, direction was to update the case diary, to produce the updated case diary. My lord, diary is not updated since, my lord, 11/5/24.
He is not connected. Petitioner is not connected with the case.
No, no.
No, whether any material till that day against the present applicant?
My lord, actually, my lord, I have seen that he has not appeared till date.
Not appeared, that is a different aspect.
different
We
aspect,
have
yes.
recalled his interim bail order.
Yes, my lord. And regarding that, but my lord, if my lord permits, my lord, 10 minutes, I'll go through, my lord.
10 minutes.
My lord, because I have seen that he has not appeared, and I have talked with the IO also, my lord, regarding that, my lord, but.
Okay, after 10 minutes.
My lord,
Attendance for hearing under order 41 rule 2 CPC. Item 22. 22.
None appears for the appellant on call, recessal is the matter after petition.
23.
Same order.
Item for orders 24.
As per official dated 10/9, the LCR is available, Lordship. So maybe.
So service completed?
Service completed.
So we can fix it for hearing?
Well, date may be fixed, lordship, but this is a long pending case, 2012 lordship.
Okay, both the parties are represented by their engaged counsel. It is submitted that service has already been completed and LCR has also been received. And as such, the matter may be fixed for hearing. Accordingly, it is provided that recessal list the matter for hearing on in the first week of November.
Specific date.
Would you better date?
12 November.
Lordship. Obliged, lordship.
25.
Maybe, Lord.
What's it? The order was passed on 25/6/24, my lord. 25/6/24, my lord. May I read out, my lord? Short order, my lord. Learned counsel for the petitioner submits that an affidavit in reply was filed in the present proceedings by the petitioner on 28/10/18. It is submitted by the learned counsel for the petition that earlier the matter was taken up along with the WPC number so and so. Therefore, the affidavit in reply file in the case might have been placed in that case and is not available in the record. What has happened, my lord, said earlier, all these cases were figured in the as a series, batch matter. They have filed the affidavit in opposition in the leading cases of that series, my lord. But copy was sent, and accordingly we replied, my lord. Now, my lord, that affidavit is not in the record, my lord. As a result, my lord, remaining documents remain unpaginated, keeping continuity of the page numbers, my lord. Now, simple prayer, my lord, that affidavit may be placed in the record before the registry so that it will come to the record, my lord. That is my submission. We have filed a reply, madam. It is evidently, madam, 2810. But their opposition, I guess, whose manner we have filed, madam, that is not in the record. They have
Acha.
filed in the leading cases.
When?
When filed?
When you have filed?
Lordship, in this case, Lordship, Mr. R. Mozumdar, he is appearing on behalf of the respondent, Lordship. Now he is out of session, but he has requested me to take time till next week, Lordship.
No, no, well, it is simple, not on the merit, my lord. Only that kindly pay the office note, lordship, because registry was directed, my lord.
Because Mr. R. Mozumdar,
Registry is to verify whether an affidavit in
he is
reply has
aware
been
of this,
filed.
Lordship.
On 16/8/18, my lord. They issued before the court, they will file, my lord. Now, my lord, if not filed, my lord, as per the report of the registry, my lord, simply they may file the report, my lord. A date may be fixed. In the meantime, my lord, they will file the, keep the affidavit in reply in the court, my lord.
That I can intimate Mr. R. Mozumdar, Lordship, to file it. If it, but it was filed in the main leading case. It was all those cases were segregated later on. That's why this problem has arisen. That I can intimate, Lordship, Mr. R. Mozumdar, to file the affidavit to the registry.
So you were referring to order? Office note?
Kuntu office note question. Kuntu office note.
Your office note, my lord, order was passed, the in view of the submission registry to verify whether affidavit.
Order dated
reply-
25/6/2024, Lordship.
25/6/24.
Yes.
Learned counsel for the petitioner submits that the affidavit in reply was filed in the present proceedings by the petitioner on 28/10/18. It is submitted by the learned counsel for the petitioner that the earlier the matter was taken up along with the WC number so and so. And therefore, the affidavit in reply filed in the case might have been placed in that case. It's not available in the record. So, my lord, simple prayer, my lord, maybe put in the record, my lord.
So we have
They will
filed
file
it in
before
the
the registry.
leading case because it is all this were listed in a series matter. So now as this matter has been segregated, that's why it is missing from the present case. So we have to file it again. That is what I understood, Lordship. I will intimate Mr. R. Mozumdar, Lordship.
Lordship, leading case was, my lord, WPC number 2017 of 17 and contempt petition was 125 of 16, my lord. It's a common affidavit, my lord, common reply in all cases.
Because it was come in a series, Lordship. There are hundreds of cases were listed in a series. That's why, Lordship.
Okay, both the parties are duly represented by the remedies counsel. The learned counsel for the petitioner submits that the respondent has filed an affidavit in opposition in WBC number
2017 of 17
2017 of 2017
and
said
contempt petition number 125 of 16
and contempt petition number 125
of 16.
2016 and said affidavit in opposition is not available in the record of this contempt petition, and as such a direction may be issued to the learned counsel for the respondent to file a copy of the same in this contempt petition. Here is accordingly allowed. The learned counsel for the respondent shall file.
I will submit the affidavit to the registry again.
Submit a fresh affidavit before the registry again. And list the matter, registrar list the matter after
vacation.
After vacation.
Kindly date 26, my lord. My lord, there is another confusion, my lord. Office note will reflect, my lord. regarding implement,
Another,
that is, order dated 4/10/23 in IA 2154. There is IA, my lord.
yes,
What has happened, my lord? During the pendency of the suit, my lord,
IA dispose of.
I dispute.
Oh.
But office note shows, my
Let-
lord, we have not taken steps regarding implement, my lord. I may be allowed to clarify that, my lord. We have taken steps, my lord. What has happened, my lord?
Hmm.
Response number 14 to 25, no? 72, we have taken steps, my lord. Subsequently, my lord, again 17, response number 17 was, my lord.
IS civil 2154.
2154.
No, yeah, this has already been disposed of.
Dispose of, my lord.
Then,
But office note shows that we have not taken steps, and this orders reflect, my lord, that not necessary to take any steps, my lord.
yeah, no order required to be passed in this regard because IA is already disposed of.
Yes.
So there is no question of taking step.
But office note showing, my lord, again and again, my lord, we have not taken steps. Then we will get it confirmed from the registry, my lord.
Yes, that will be better, Lordship. Yes.
Kindly date may be fixed, my lord, subject to your lordship convenience, my lord. Maybe after application, my lord, then.
Take a date from him.
Lordship.
27.
Twenty-seven, again, I am appearing on behalf of Mr. R. Muzumdar Lordship. He is out of station, so we need accommodation. And moreover, Lordship, the respondent number 1 has retired 4 years back, and respondent number 3 has already been expired. So he have to implement the new incumbent. That will be better for the petitioner also, Lordship.
But my lord, the contempt is, my lord,
Now, when the person expired, how can he defend, come and defend the Lordship, Lordship?
but if lordships allows me, my lord, earlier, my lord, the counsel from the, my lord, contemnants, respondents, my lord, has, my lord, even an undertaking before this honorable court to pay the salary. Thereafter also, my lord, we have again.
Then,
compelled
Mr.
approach.
Let it come next week. Let R. Muzumdar come, Lordship. He will explain, Lordship.
Okay, as agreed by learned advocates of both the parties, SSL is the matter. Govind,
Release after a week.
My lord,
It will go after vacation.
my
after
lord,
a week.
My lord, some of the petitioners, my lord, who has already retired, my lord, has approached before this honorable court by filing one writ petition, my lord. That writ petition is pending, my lord. Can it be, my lord, clubbed together, my lord? Because that writ petition is for pension. That writ
Okay,
petition.
what are the
The pension
numbers?
is
Number,
different.
my lord, 635 of 2023. Some salary, my lord, is not different, my lord.
65 of
635 of 2023.
635.
My lord,
Okay, 2023.
my lord.
Mr. Verma, learned counsel for the petitioner, submits that in connection with a similar matter, another writ petition being so is pending before
635.
the court.
2020.
And accordingly, price for listing both the cases together, pair is allowed, rescission to the netball and disregard.
Like,
Are
28.
The order is at page.
Lordship, the petitioners need to include the new incumbent here because Lordship, all the others are retired Lordship and transferred Lordship. No, director Lordship. Director. I'll give the name Lordship.
No, is it the legal position that someone newly
In contempt cases, Lordship, because by name is there, so that is required.
is it by name?
By name, Lordship. Contempt case.
I am required to impeach the new incumbent, but it does not absolve them from their responsibility as to why they did not do the
That
compliance in their tenure.
yes, that is natural. Respondent number 2, Lordship. Contempt number. Sorry, contempt number 1.
Respondent number 1 retired.
Lordship, now new incumbent has come.
In
Direct-
place of respondent number
yes.
one.
Director has now new, Mrs. Pomi Borua has come. She needs to be on Lordship.
We have implemented the new incumbents quite a number of times. So recently, the last implement was of Dharmakanta Milimed. Now, since he is no longer there,
He is no longer there. Lordship. He has been transferred.
Mr. Your good name?
P. Bharadwaj.
A.R. Tohbildar.
Here,
Tohbildar
law builder, learned counsel for the respondent,
for the director, Lordship. Director Higher Education.
director higher education submits that in place of respondent number one, new incumbent has been appointed. And as such, the petitioner has to implead him. Implead the new incumbent, that's respondent number one. The learned counsel for the petitioner submits that he may be granted 2 weeks time.
And I'll require 4 weeks time because I have to send a notice also.
2 weeks. Okay, 2 weeks
In
time
place of-
to implead the new incumbent as respondent number one. Here is accordingly allowed, rest is the matter after 2 weeks.
That's in place of respondent number 5, not respondent number 1.
Because the last implement, the last director who was implemented was.
Respondent number 5
5. It should be
instead of
5.
1.
Instead of 1, it should be respondent number 5.
Okay, respondent number 5.
Obliged.
Obliged.
Bill application. Second anticipatory bill application. FIR at page 15. May I read?
Yes.
With due respect, begs to state that yesterday on 9/12/2023, my driver, namely Mohammad Ashraful Alam, was transporting 8 number of cattle on my vehicle bearing registration number so and so, Mahindra G2 to Nagaon by way of purchase from a person from Borwa Tiniali, and while passing through Tipling Tiniali, some people in a car white last registration number 3101 stopped our vehicle and assaulted us and threatened to return the vehicle to the field. On Tripling School, forcefully parked the vehicle on a dark spot and then again beat us and demanded the parcels receipt of the cattle and threatened to kill us if we failed to show them. And on fear, we handed over the receipts to them. And on demand of money from us, I had an amount of 6,000 and my driver had an amount of 20,000, which were handed over to them. They threatened us if we did not hand over the money, they will kill us. Later on, we informed the seller of the cattle who came to the spot, and he told that he sold the cattle to us. Though they threatened him to leave the spot, they untied the ropes of the cattle, and accordingly the cattle came out from the vehicle. And on fear somehow flee from the spot and came to the police station. Later on, with the help of the police personnel, recovered 4 number of cattle. Now the initially it was registered under 387 and 34. Thereafter, Lordship, 388 was added and 25(1) of the Arms Act was added. That there is no allegation of Arms Act whatsoever. Moreover, Lordship, I will show that 25(1) is for prohibited arms. What was recovered from the license recovered from my home is not for non-prohibited. Moreover, only 388 has a punishment of 10 years or more, and 388 absolutely doesn't apply. It is of a different circumstances. Now, Lordship would see the previous order at page 21, 22, Lordship. Your Lordship had narrated the entire incident at para 7 at page 20.
Okay, yes, Mr.
At this
Professor.
stage, matlab, only CD may be called for arms act that is section was earlier was not properly now only at that point of time
No,
387 was there.
investigation is completed or investigation is still
Matlab,
going on?
we don't know, my lord, because they have not annexed and it is on motion stage, my lord. So we have to take instruction, my lord, whether if succeed late or not.
Let the city come, Bora.
Yes, Lordship, but the thing is that the question of Arms Act would not apply that. That section is for prohibited arms. My is non-prohibited arms, the license that is seized from my home. Secondly, my.
Have you enclosed the copy of license?
Yes, 29A, Lordship, 29A, everything is there. Everything, whatever we found out from the record, Lordship, everything is annexed. 28A, Lordship, license is also annexed, 29A, Lordship, would see. NP, non-prohibited. Renewal also page 30.
Let the city come, we will see.
Lordship, my name is not there. There may be unknown persons, but no allegations against me because of an witness telling my name. I have been regularly harassed, Lordship. That's all, Lordship. Till then, I may be protected. It is the second time.
No.
And other offenses.
Earlier, after perusing the case diary, it was rejected. Therefore, we will not
because
grant
it
you
was in
any.
essence stage, Lordship, only because of that. Lordship, para 7 at page 23, Lordship will kindly peruse. Why Lordship had rejected? Para 7, may I read, Lordship? The case diary indicates that the IO has collected sufficient encrypting materials against the accused and the investigation is in the nascent stage and the co-accused are yet to be arrested, and extending the previous bail to the applicant at this stage will misdirect the investigation and accordingly the petition stage.
No, here it has not been mentioned whether the arms is prohibited or not.
Page 27, Caesar list, my lord, there annexed. .32 pistol along with 10 numbers of 7.65 live ammunitions. Maybe this is not prohibited, but these were seized.
Lordship, at page 26.
Okay, let the city come.
Section
Sort
may
that.
be very well at that point of time.
What Mr. P.T. Bora, learned counsel for the applicant, and Mr. Parasar, learned additional PT for the status.
An injury report also, there is a allegation of beating them or something. Still, therefore, Lordship, injury report may be also
It will
false.
come in the case diary. along with that.
Injury report may be also false because that is absolutely false.
This application under section 482 of the BNSS 2023 is preferred by accused Mukumani, applicant Mukumani Bora, who has been apprehending arrest in connection with Dulia's and PS case number 317 of 2023 under section 387, 34 IPC, read with section 388 IPC. Edit section 388 IPC and section 25(1) capital A of the Arms Act 1959. Having heard the submission of learned advocates of both the parties, it is provided that Mr. Parasar, learned additional PP, shall produce the case diary before this court on
24th.
24th. Deep.
Any other number? 60?
Lordship, my senior is on legs at court number 8. Matter may be adjourned for the day and fixed after vacation, Lordship.
No. If we fix it after vacation, the petition would be infructuous.
Yes.
Next
Next week was next. 17.
No, today is not fixed for hearing. On the on the other day, we have already heard both the side. Today is fixed for only this submission of this citation only. You produce the citation.
Actually, Lordship, on first half, my senior was here present, but petitioner taken the time, that's why, Lordship.
And it, my lord,
No,
on
maybe.
Tuesday, my lord, Lordship may fix it because, my lord, I will have to submit, my lord.
Pardon?
I am for the respondent number 3, my lord.
Respondent number 3.
My lord.
Headmaster.
Since, my lord, counsel for the SEBA is, my lord, today is some difficulty, my lord. So on Tuesday, my lord, the
Tuesday.
Lordship fixed
Not in 17 Lordship, except 17.
17, Tuesday.
17
When?
Except 17 Lordship. Except 17 Lordship. Next week, 18, 19, 20 Lordship.
Okay, as agreed by learned advocates of both sides, the SSL is the matter on 19.
19.
Okay.
As a part of
Yes,
us.
fixed item.
My lord, 19, my lord, I have difficulty, my lord, 19. 20, my lord.
20, okay.
20.
24 then. 20.
20.
Admission,
Friday.
admission.
Okay.
Friday.
Okay, okay.
20.
Friday.
Friday close.
20.
As part of us.
24 or 20?
No, 20. 20.
24.
20.
24.
24.
20.
20.
24 level.
20.
Item number 20, timing.
Online.
Yes, my lord, there are other cases also, my lord. Though bulky case that I have gone through and I have talked with the IO also, my lord. In other case, he has, my lord, some, my lord, but in this
In
present
other
case,
case
he
means
is,
which case?
in one of the case, my lord, the dispute PS 2291 of 23.
No,
he-
this
present case, my lord,
application is filed in connection with dispute PS case number 2497 of
97, yes,
2022.
2497, my lord. He is one of the partner of the main accused, but his specific is nothing, my lord.
Nothing.
Nowhere, my lord, no.
Nothing.
But in other case, my lord, he is difficulty, my lord, because of that, my lord, I have gone through.
Maybe we are not concerned with other cases.
Yes, yes, yes.
Heard Mr. D. Gusami, learned counsel for the applicant, and also heard Mr. Porasor, learned additional PP for the state respondent. This para number 2 and 3 of page number 4. Mr. Gusami, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR, except that he has connection with one Deposit Nath,
Yes.
who is the principal accused here in this case. And he was granted the privilege of interim PRS bail white order dated 11/6/2024, but due to some inconvenience, he could not appear before the IO, for which this court white order dated white order dated 19/7/2024 was placed to recall the order dated 11/6/2024. And that the applicant is ready to cooperate with the investigating agency, and therefore Mr. Gusami has contended to allow this petition. On the other hand, Mr. P.S. Lawcore, learned additional, KK Porasor, learned additional PP, has produced the case diary before this court and submits that the materials so far collected in the case diary are inadequate to show the complicity of the applicant with the offense alleged in the FIR. However, Mr. Porasor submits that in some other cases, his complicity is there as reflected in the case diary. Having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on record, and also peruse the case diary produced by Mr. Porasor, learned additional PP. In view of the materials collected so far in the case diary, and also in view of the submission of learned advocates of both the parties, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this application. It is provided that in the event of arrest of the applicant in connection with dispute PS case number 2497 of 2022, under section 420, 468, 471 IPC, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above release is however subject to the following three conditions. The three conditions already by. In terms of above, this AB is the disposal of CDB return.
Item number 29.
Matter may adjourn for the time alert.
Pardon?
Adjourn for the day. And fix on 25th of September along with contempt case number 128 16 my lord.
Contempt case number
128 2016.
128
Yes, my lord.
of 2016. The parties are represented by their engaged counsel, and it is submitted that this matter may be listed along with contempt petition number 128 of 2016. Accordingly, it is provided that registrar shall list this contempt petition along with contempt petition number 128 of 2016. When it is fixed?
25th of September.
25th of
My
November.
lord, R. Mazumdar won't be available on 25th.
September, my lord, September.
On 25th September, R. Mazumdar won't be available.
When?
So he will be out of station. So
When?
kindly fix some other day.
Lordship, another similar matter fix on
Maybe on 24th.
24th. So connected matter has already been listed.
But the conducting standing counsel R. Mazumdar, he will be out of station on that particular day.
But someone may appear on his behalf.
30.
Lordship, in this matter, service has already been completed via for the respondent. LCR has also been received. A date may be fixed for hearing, your lordship. Immediate.
LCR receipt.
Yes, your lordship.
The parties are duly represented by their engaged counsel. It is submitted at the bar that service completed and LCR has been received and the matter may be listed for hearing. Accordingly, it is provided that registrar shall list the matter for hearing in usual course.
A date may be fixed, your
Sorry,
lordship, in the month of October itself.
31.
Registry will fix.
Right, like, lordship, service complete on respondent number 1 to 5, my lord. And 6 is not necessary party, my lord. So he may be strike off, my lord, from the post title. And LCR received, my lord. Matter may be fixed for hearing, my lord.
Third, Miss,
L. Sharma.
learned counsel for the appellant. None appears for the respondent on call. Ms. Sharma, learned counsel for the appellant, submits that respondent number 6 is not a necessary party here in this appeal. And as such, the name of respondent number 6 may be struck off from the array of this petition. Here is accordingly allowed. Strike off the name of respondent number 6 from the array of this petition at the cost and risk of the appellant. It appears that LCR has already been received and the matter is ready for hearing. Accordingly, it is provided that registrar shall list the matter for hearing in usual course.
Oh, bless me.
32.
May I please, your lordship, in this matter, due to some difficulty, we could not take steps up in respondent number 2 Roman 3. So 1 week time may be granted, lordship.
1 week.
On a new address, lordship.
Your good name, please?
D. Chaudhary.
D. Chaudhary.
D.
D. Mr. D. Chaudhary, learned counsel for the applicant, submits that he may be granted 1 week time for
Steps upon 2 Roman 3.
step upon 2
Respondent number 2
Roman 3.
2, 3. We can make it 2 Roman 3. Pair is accordingly allowed. Should be taken by registered post with AD and also by usual process
On a new address now.
within a week. List the matter after 4 weeks.
Any new address also. New address.
New address. Okay, you have to issue the same in new address.
Okay.
33.
Please, Your Lordship. Your Lordship, this is an application under section 24 of the Code of Civil Procedure, Your Lordship, for transferring a title sole matrimonial number 13 of 24 from
Where to where?
From my lord, District Judge Bozali to Principal Judge Family Court in Guwahati, my lord.
Kamrup Metro, Your Lordship.
My lord,
Family court, Guwahati.
Yes, Your Lordship.
My lord, respondent has no objection, my lord, in transferring the.
No objection.
My lord, only without admitting the facts narrated in the petition.
Heard Ms. Becca, learned counsel for the applicant, and Mr.
UK does, my lord.
UK does, learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure, read with Article 227 of the Constitution of India, is referred by applicant for transferring of TSM, case number TSM 13/2022, pending before the Court of Learned District and Session Judge Bozali, Pachala, to the Court of Learned Principal Judge Family Court in the District of Kamrup M, Guwahati. The applicant is residing in Guwahati.
Yes, Your Lordship.
The learned counsel for the applicant submits that the applicant is presently residing at Guwahati. Which place of Guwahati?
Kailipara, Your
At
Lordship.
Kailipara, Guwahati. And that the respondent has filed a case for dissolution of their of her marriage at in the court of district judge district judge Bozali, Pachala, and that she has difficulties in appearing in the court of learned district judge at Bozali, and therefore it is contended to transfer the aforesaid proceeding from the court of learned district judge Bozali, Pachala to Principal Judge Family Court, Kamrup M, Guwahati. Third, thus learned counsel for the respondent submits that he has no objection in the event of allowing this petition. Para, having heard the submission of learned advocates for both the parties, I have gone through the petition and the documents as on record. And considering the submission of learned counsel for both the parties, and as agreed upon, this court is inclined to allow this petition. It is provided that title suit number
13
and 13 of 2022, pending before the Court of Learned District Judge Bozali, Pachala, be transferred to the Court of Principal Judge Family Court number 1, Guwahati. The petitioner, the applicant shall obtain a certified copy of this order and place the same before the Court of Learned District Judge Bozali, Pachala, and on receipt of the same, the Learned District Judge Bozali, Pachala shall transmit a record of TSM number 13 of 2024 to the Court of Learned Principal Judge Family Court number 1 within a period of 1 week from the date of production of certificate copy. In terms of above, this transfer petition stands disposed of.
If you oblige.
Interim may be regulating. There is an interim, my lord. Stay was granted.
Interim order passed earlier stands recalled.
34.
May I please, your lordship. Lordship, as per office of the death 7/9/24, step not taken on respondent number 12, lordship. And respondent number 3 has already died. And subsequent petition is also not filed, lordship.
None appears for the applicant on call. However, Mr.
D. Borua, on behalf of respondent number 4.
Learned counsel for the respondent number
4.
4 present. Office note dated 7/9/2024 indicates that the applicant has not taken any step upon respondent number 12. And also had not taken any step to implement the legal heirs of respondent number 3 who had suffered demise. So list the matter after 1 week. In absence of, no, in the event of subsequent non-appearance of the counsel for the applicant, appropriate order shall follow.
I'm for respondent 1 and 2.
35.
May I please, your lordship? We have already taken step, my lord.
Pardon?
LCR. My lord. We have already taken step, my lord.
LCR not received.
LCR not received. Respondent.
Service completed.
Yes, my lord.
Heard, Mr.
A. Gohain.
Learned counsel for the appellant. None appears for the respondent on call. Office note dated 27/6/2024 indicates that LCR has not yet been received. Accordingly, it is provided that rest is also reminder to the learned trial court as well as first appellate court for transmitting the record without further delay. List after 4 weeks.
36.
Here, as per office note dated 11/9/2024, my lord, records have not yet been received, my lord.
Both the parties are represented by their English counsel. Office note dated 11/9/2024 indicates that LCR has not yet been received. Accordingly, it is provided that receipt shall also reminder to the learned trial court for transmitting the record without further delay. Trial court within bracket Civil Judge Senior Division number 1 Kasar Silsor. After 4 weeks.
37.
Lordship, as per office note dated 5/8/2024. We could not able to take fresh steps. So 1 week time we kindly be granted.
Heard, Mr. Your good name?
You Agarwal.
You Agara, learned counsel for the petitioner. Office note dated 11/9/2024 indicates that neither edit card nor unserved notice issued to the respondent received by the registry. You want to take fresh step or will await service report?
Service report.
List the matter after 2 weeks, awaiting service report upon respondent.
Thirty-eight.
Peter Lordship, as per office note dated service report is awaited. And Lordship, one IACR, I filed for
Hmm? Heard, Miss?
A Hussain.
Learned Counsel for the appellant. Office note dated 10/9/2024 indicates that no service report has been received till date in respect of sole respondent. On the notice issued on 8/8/2024. An unserved notice issued to the sole respondent returned with a postal report that address is not traceable, returned to the sender. So you have to take fresh step.
Lordship.
Accordingly, it is provided that learned counsel for the appellant shall take fresh step upon the sole respondent, obtaining necessary instruction in respect of his address. Said office note also indicates that LCR has not been received. The LCR from the learned first appellate court has not yet been received.
Lordship, one
Yes,
one IACR
I is for what?
for staying judgment and decree date.
So receives a issue reminder to the learned first appellate court to transmit the record without further delay. So in the IA, no stay was granted, but directed to issue notice. If certain notice thereafter, we will see. In IA, you take down hard case so and so learned counsel for the applicant. Office note dated 10/9/24 indicates that no step has been taken upon the respondent till date. Accordingly, it is provided that the learned counsel for the applicant shall take step upon respondent number upon the sole respondent person to order dated 2/8/2024. You take step.
Lordship.
Interim pair will be considered on appearance of the other side.
39.
Respondent.
May I please? Lordship, IA 206 is for seeking condonation of delay, madam, in preferring the substitution petition.
Yes,
I have filed objection.
objection. You have objection.
It is a part of the application.
Well, what is your objection?
Normally, it was not properly explained, Lordship.
Abnormal delay.
My lord, appellant number 1 and appellant number 2 were husband and wife, and both of them expired. Now the applicants are their children. So they were not aware as to the pendency of the case. Now subsequently, my lord, appellant number 2 expired in November 2017 and appellant number 1 expired in September 2018. But since the children were not aware as to the pendency of the case, subsequently, my lord, in November 23, my lord, they came across a document by virtue of which they learned that as to the pendency of the case. And thereafter, my lord, they approached us and accordingly we filed this application.
You are for the insurance company.
Yes. Moreover, my lord, there has been a kind of amicable settlement, my lord, between the parties. So it's most likely that my lord,
Amicable settlement.
my lord. So my lord, it's most likely that it would be placed before the Lok Adalat. Only problem is that my lord, until and unless my lord, the applicants are substituted, my lord, they would not be in a position to get that.
Okay, then settle the matter. Then look at a lot.
Without substitution, my lord,
it is not possible.
that is
Not possible. We will allow this application.
nice.
So you will gain nothing. You have to pay the amount. Otherwise, it will carry interest at the rate of rupees. What is the rate of interest?
My lord, as per trial court, my lord, it is 6%.
6%.
Now the date of judgment is 2010.
10.
Yes, already 14 years has been.
Heard Mr. Your good name?
HK Sharma.
Learned counsel for the applicant and also heard Mr. HK. Your name? This application under section 5 of the Limitation Act 1963 is preferred by the applicant. For condonation of delay of 1,422 days in preferring application for substitution of legal heirs of
Both the appellants, appellant 1 and appellant number 2. Both were husband and wife.
Lasit Sona.
Lasit Sona was the husband and Matlab Saraswati Sona was the wife. Both of them is already explained.
And Srimati Saraswati Sona. The learned counsel for the applicant submits that the appellant struck claimants number 1, Sri Lasit Sona, suffered demise on when?
7/9/2018.
7/9/2018 and Srimati Saraswati Sona suffered demise on
25/11/2017.
25/11/2017. And their legal heirs were not aware of pendency of the proceeding before this court. And therefore, it is contended to condone the aforesaid delay. On the other hand, learned counsel for the respondent submits that the delay has not been properly explained, and therefore he has objection in the event of condoning the same. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record. And the statement and averment made in the application explaining the cause of delay. And also, I have carefully gone to the affidavit in opposition filed by the respondent. Having considered the submission of learned advocates of both the parties, and also considering the statement and averment made in the paragraph number 3, 4, and 5, this court is of the view that the delay in filing the substitution petition is sufficiently explained, and therefore this court is inclined to allow this application. Delay of 1,422 days in filing the substitution petition expense conduct.
IA 211 is for setting aside the abatement.
Art, Mr. Sarma, learned counsel for the applicant, and Mr. So learned counsel for the respondent. This IA is preferred. Now, this interlocutory application is preferred under Order 22 Rule 9, reduced Section 151 of the Code of Civil Procedure for setting aside the abatement of the appellant number 1, Sri Lasit Sona and Srimati Saraswati Sona. The learned counsel for the applicant submits that an interlocutory application for condonation of delay in substitution petition has already been allowed by this court. And as such, the abatement may be set aside. Having considered the submission of learned advocates about the parties, this court is inclined to allow the application, and accordingly the abatement is then set aside.
210 is for substitution.
This interlocutory application is preferred under Order 22 Rule 3, reduced Section 151 of the Code of Civil Procedure for substitution of legal heirs of the appellant. The learned counsel for the applicant submits that the appellant Sri Lasit Sona and Srimati Saraswati Sona have suffered demise, and as such, their names on such and such that, and as such, their legal heirs are required to be implemented in their place. Having heard the submission of learned advocates about the parties, this petition stands allowed. The name of the applicants be implemented as respondents in the MSC appeal number so and so so and so.
My lord, as appellant. They are the appellants, my lord, as appellant in the appeal method.
No, now their names are to be substituted in the appeal.
Yes, my lord, as appellant, my lord. My lord has dictated.
As appellant, yes.
And my lord, for this matter may be listed tomorrow, my lord, before the local element. That may be reflected.
Tomorrow?
Tomorrow.
How it is possible?
Because talk of compromise is going on, Lordship, already matter is settled outside the court.
Settle
Lordship. That is why Lordship is formal order is required tomorrow.
tomorrow. Acha. Okay. But their names have to be reflected in the cause title. Possible tomorrow. They also have to reflect it in the cause list tomorrow.
Lordship.
Tomorrow not possible, I think. I don't have any problem in referring the matter to look at tomorrow. But you inquire from the registry whether it will be convenient for them to list the matter tomorrow or not.
The supplementary list it may come, Lordship.
Supplementary. Are you sure? You inquire from the registry? You inform this court? After some time?
After some time.
After some time, you inform this court. If possible, we will refer it, no
Fine.
problem.
Supplementary list to our into the section of what contract.
We will cover for it. Okay, you inform the court.
4041.
This ISCB list for stay of operation of judgment and decree dated 10/11/2010. According to the page number 6, advice given by this honorable court. By mistake, it was earlier applied, but the page number 8, para number 3, this honorable court have given liberty if the party wants so that the judgment and decree dated 10/11/2010 in case number 933/2006 passed by the Civil Judge Junior Division number 2.
What is page number 8?
Page number 8 is the order passed by this honorable court. Previously, the applicant applied or by mistake a petition that was the stay of judgment and operation passed by the district and the district judge. But the original court is the Civil Judge Junior Division number 2. They may execute the execution of this order passed by the court, and this order is annexed here with judgment.
No,
and
no,
decree
it is
number 9.
reflected that the application filed under section 5 of the Limitation Act was dismissed. And as such, the order cannot be stayed. And the application is misconceived. And accordingly, stands dismissed.
This earlier petition was dismissed, giving liberty, para number 3. This honorable court has given liberty, be that as it may be a liberty, however, is given to the applicant to file appropriate application for stay of the judgment and decree dated 10/11/2010, passed in title suit number 933/2006, if so advised. The party has given instruction us to file an application to stay this judgment and decree dated 10/11/2010.
Yes, you have responded.
Yes, we'll file the objection.
When?
Kindly give short date.
Okay. Pardon me, sir, your good name, please?
H. Bhuya.
H?
Bhuya.
Oh, yeah, learned counsel for the applicant. This application under Order 41, Rule 5, read with Section 151 CPC is prepared by the applicant for staying the judgment decree dated 10/11/2010, passed by the learned Civil Judge Junior Division number 2, Kamrup M, in title suit number 933/2006. The learned counsel. What is your name?
M. Inti.
M.
Inti on behalf of
Inti.
I. Chaudhary.
Learned counsel appearing on behalf of Mr. I. Chaudhary. Learned counsel for the respondent submits that the respondent will file objection in this petition and prays for granting her 1 week time.
Before Puja vacation.
Okay, 2 weeks time to file objection. Where is allowed, recess shall list the matter after 2 weeks.
Obliged.
Item 42.
41. Oh, 41. Your lordship, I want to withdraw IA 457, 2015. And admit petition number IA 2665, 2024.
41.
457 withdraw and admit to 2665 IA.
You are for?
I'm from Rifayat Ali. Rifat Ali.
Item number 41.
Yes.
IA number?
IA number 457, 2015 to withdraw.
You want to withdraw this?
Yes, lordship.
Pardon me, your good name?
And Khatun.
M. Khatun, learned counsel for the applicant. Ms. Khatun submits that she has the instruction to withdraw this application. There is accordingly allowed this IA since disposal on withdrawal.
Your lordship may be admit IA 2665, 2024. Same cause name.
Okay, heard Ms. So-and-so, learned counsel for the applicant. This application under order 41 rule 5 read with section 151 CPC is preferred by the applicant for staying of judgment struck decree dated 10/11/2010 passed by the learned civil judge junior division number 2 Kamrup M entitled suit number 933 of 2006. Let notice be issued to the respondent returnable in 4 weeks. Is to be taken by registered post with AD and also by usual process within a week from today.
$42.
Obliged.
This IA minded 2747 of 24 has been filed for withdrawal of 220 lakh rupees deposited by the insurance company. Apparently.
Yes, you are for
And for the insurance company, lordship.
insurance company.
Lordship. I have no objection, lordship.
Heard Mr. Bhattacharya, learned counsel for the applicant, and Mr.
Arsham,
R. Sharma,
lordship.
learned counsel for the
Insurance company.
respondent insurance company. Respondent number 1, Oriental Insurance Company. This application under this interlocutory application is preferred by the applicant for allowing him to withdraw a sum of rupees 20 lakhs deposited by the appellant, the Oriental Insurance Company, before the registry of this court pursuant to the order dated 19/8/2024 passed in IA within bracket civil number 2439 of 2024 arising out of MSC appeal number 401 of 2024. Mr. Sharma, learned counsel for the respondent number 1 submits that the respondent number 1 has no objection in the event of allowing this IA. Para, having considered the submission of learned advocates of both sides, this court is inclined to allow this application. It is provided that bond is required to be given or not required to be given.
Not required.
Not required to be given. Accordingly, it is provided that registrar shall release the amount of rupees 20 lakh in favor of the applicant after proper identification and verification.
Without any rider, can it be written like?
Not necessary.
Since,
if we not impose any restriction or rider, why should we?
The trial court has said 10 lakh to be deposited in FDR.
Pardon?
In the trial court judgment, madam, there is a direction that
Okay,
10 lakh
without any rider, okay.
applies.
At number 43 by VC mode.
I is for continuation of delay, Your Lordship.
It is your worship, my lord. Actually, this,
Yeah.
as per official, my lord, there is a delay of 85 days in filing the connected charge, second appeal, my lord. For which this interlocutory application has been filed under section 5 of the Limitation Act for continuation of delay, my lord. Let that notice be issued, my lord, to the respondent, my lord.
Yes, heard Mr. NC does, learned senior counsel, assisted by Mr. A does, learned counsel for the applicant. This application is preferred under section 5 of the Limitation Act for condonation of delay of 85 days in preferring connected regular second appeal against the judgment and decree dated
Judgment order dated 21st of December 2000.
8-4, my lord. 8-4, sorry. It's a 6-3 to 2024, my lord.
Yes, 21/12/2023 and sign on 6/3/2024
24.
and the decree dated 6/3/2024 passed by the learned district judge Lakhimpur, North Lakhimpur in title appeal number 02 of 2022.
Thank you, madam.
Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. List after 4 weeks.
Obliged to your lordship.
My lord, then item number 39, my lord, the appeal may be taken after 2 weeks, my lord, because I need to file the amended cost title. Thereafter, my lord, it should be amended in the thereafter. my lord.
39.
Yes, my lord. Thereafter.
Let
my lord,
MSC appeal.
My lord. So in the MSC appeal, my lord, it may come after 2 weeks, my lord. I will file the amended cost title.
39 পুনে লৈছিলে তাক কৈ দিব better may be listed after
2 weeks, my lord. In
2
the
weeks,
meantime, I
so as
will
to
file the-
enable the learned counsel for the applicant to file amended cost title.
My lord.
Okay.
Much obliged.
24.
Wait, please, your lordship. Lordship, this I is listed for the first time, lordship. There is delay of 293 days.
Heard, Mr.
SP Sharma, lordship.
Learned counsel for the applicant. This application under section 5 of the Indian Limitation Act is preferred by the applicant. Oriental Insurance Company Limited for condonation of delay of 1963 days in preferring appeal.
293 days.
Pardon?
293 days, lordship. In page number.
Yes,
2.
next page, yes, 293 days in preferring connected appeal against the judgment dated 12/12/2022 passed by the Learned Commissioner Employees Compensation Barpeta in EC case number 142 of 2022. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. List after 4 weeks.
45.
Lordship, here also the delay is 393 days, lordship.
Say.
26.
Here the delay is, lordship, 298 days.
Okay.
47.
Lordship, here the delay is 393 days, lordship.
Okay.
48.
Lordship, here the delay is 303 days, 303.
Okay.
49.
There will be delay of 16 days.
60 days.
16, 1/6 minute.
1/6. It is for enhancement.
Enhancement, ma'am.
Well, let notice go.
50,
After 4 weeks,
Madam 50,
none appears for the applicant confirm, rest is the less the matter after 1 week.
51,
Lordship, here the delays of 50 days, Lordship. And respondent number 1 has already appeared.
You are for?
Respondent number 1, claim name.
Any objection?
Sir,
Only 50 days, Lordship.
so we need time for 2 weeks.
50 days. Okay. Heard Mr. Sharma, learned counsel for the applicant, and Mr.
80 Sarkar.
Is
80 Sarkar. 80
Acha, 80 Sarkar, learned counsel for the respondent number
1.
respondent number 1.
Babul Gwala.
Babul Gola. This application under section 173 of the MD Act. Read section 5 of the Limitation Act 1963 is referred by the applicant for condonation of delay of 50 days in preparing appeal against the judgment and decree. Judgment and award dated 12/10/2023 passed by the learned MSCT. Learned member MSCT number 1 Kamrup M Guwahati in MSC case number 2082 of 2017. Let Mr. Sarkar, learned counsel for the respondent number 1 submits that he may be granted 2 weeks time to file objection. Here is allowed. This is a matter after 2 weeks.
52,
Let notice be so. However, no formal notice is required by Mr. Sarkar appear on behalf of respondent.
52, Madam 52,
None appears for the applicant on call. This is the matter after 1 week.
53,
Same order.
54,
Listed for the first time, it is a delay of 29 days. Defined that.
Issue notice. Submit taken by registered post with ADA and also by usual process within a week from to the list after 4 weeks. Good.
items for stay, item 57.
My lord. Please revision petition, my lord. Please get order dated 4/8/23. By the said order, the petition of the petitioner, that is now the plaintiff petitioner, and we rejected. In that petition, we have prayed for allowing us to submit some of the documents, that is income tax returns of the plaintiff. Income tax returns of the plaintiff. That we sought to be produced before the court. The case is, the hearing of the case has not yet started. Case was just the stage of issue and document status. Hearing has not been started. And we have filed, on previous date, we have filed WHS against counterclaim of the defendants. My lord, the order reasons for rejection of the petition are that the last paragraph.
Where is the order?
That is, order is page number 55.
And operative person?
My lord, last page 57, last part. I have perused the contents of plaint, and on such perusal, I find that the plaint contains no plea whatsoever regarding filing of income tax return of the plaintiff for any assessment year. The additional documents sought to be filed by plaintiff are beyond their pleading, as such petition is rejected. But my lord, firstly,
So, if you want to file any documents later on, you have to indicate it in your plaint.
my lord,
That is the requirement of law.
like the petition the documents regarding my documents already we have mentioned in our WS against counterclaim. Perhaps the trial court did not see the WS against counterclaim. The defendant had filed a WS cum counterclaim in which they have stated that this much amount cannot be paid, 5 rupees, 5 lakhs has not been paid because the plaintiff cannot pay as per income tax. So we have replied to them, we said that no, we have paid it and that is reflected in our income tax returns. That is why, my lord may kindly see that WS cum counterclaim. My lord knows that counterclaim is just like a suit. It is just like pro suit.
Yes, page number.
My lord. They are repeatedly stating it. Firstly, page number 26 may kindly visit, my lord. Page 26.
Yes.
Fourth line. After signing of the agreement, the plaintiff stated that as per income tax department notification, they cannot
Page number 46.
Running page 26, my lord.
26.
Running page 26.
Yes.
Fourth line. After signing of agreement,
Hmm.
that plaintiff stated that as per income tax department notification, they cannot pay rupees 5 lakhs in cash and they will make payment by bank transfer within a week. However, plaintiff did not make any payment. Only after much process total rupees 1,50,000 paid. That is here. Then my lord may again say they are specifically taken in counterclaim, my lord. The counterclaim. Counterclaims start from page number 33. Counterclaims start from page 33 and we may see from that page 33 itself, para 24. The defendant one is wife.
Page number 30.
33, running page 33, my lord.
Yes, para number
24.
24.
Their counterclaim starts. The defendant one is wife and only legal heir of late Rajan Sundar Das. Through agreement dated 28/2/17 was signed, no payment was made at the time of signing of the agreement. As plaintiff stated that they will make payment only after registration of the agreement. And they did not make the payment of the 5 lakhs as stated in the agreement, stating that they cannot make cash payment as per income tax guideline. After signing of the agreement, plaintiff stated that as per income tax department notification, they cannot pay rupees 5 lakhs in cash and they will make payment by bank transfer within a week. However, the plaintiff did not make any payment. So, my lord, what was the case? Actually, my case was that you have agreed to sell one plot of land to me. And against that plot of land, on the date of signing of the agreement, you have taken cash rupees 5 lakhs from me. And thereafter, we have paid further amounts 3,50,000 by NEFT. So now he wants to say that I did not pay the amount, although he has signed the agreement acknowledging receipt of rupees 5 lakhs. But he want to say that
no, that is an admitted position that 5 lakhs cash transaction cannot be made in view of the.
That I shall settle with the income tax department. Whether it can be made or not, that income tax department will take care of it. If I have made any violation of law, I shall be punished according to income tax department.
No, who will pay? He will pay.
I have paid.
You have.
But we have paid it and they have acknowledged the receipt. Whatever income tax department says, they can make some punitive action against me, like if I have paid them. But they have acknowledged the receipt. Now, what is my WS against the counterclaim, my lord?
Yes, so what is your submission?
My WS, my WS.
Please, Your Honor, I'm appearing on respondent number 1 and 3. My humble submission before Your Honor, Lordship, that the petitioner has not stated anything in the plain regarding income tax return of the petitioner for the relevant period of time. The assessment year 2017, 18 and 18, 19. They plead the 5 lakhs in connection with the income tax return is plea taken by the respondent in the written statement come a counterclaim. And the petitioner in the plain, they stated the 5 lakhs in cash is paid was paid to the defendant, but they did not say anything the income tax return. If a 5 lakhs rupees is cash is paid, was paid to the respondent, Your Honor, Lordship, then they're supposed to tell, especially they have written in the income tax return, Your Honor. And the Your Honor, and in the order, Your Honor, the page 56, Your Honor. Lordship, the learned counsel for the plaintiff did not turn up the hearing at the time of hearing before the trial court. They did not argue the petition, Your Honor.
Now, what is your objection?
My objection, Your Honor, is specific, Your Honor. The
No plea was taken in the plaint.
not the plea taken by the respondent, Your Honor, in the written statement come counterclaim. In the plaint, there is no specific affirmation as well as statement.
No, if you have filed a counterclaim, then he is supposed to reply to the same. Reply to the counterclaim.
Lordship. But in the order dated 4/8/23, Lordship, the petitioner did not argue the petition, Your Honor. This
No,
reflected
maybe
in the-
whatever may be there, but he is entitled to file a reply to the counterclaim filed by you. Is it not correct? Let him file. How prejudice will be caused to you? In which way? If anyway, if you suffered prejudice, you saw it. If there is no prejudice, no prejudice is caused to you, then let him file the document. Heard, Mr.
S. Sorma.
S.
S. Sorma.
Sarma, learned counsel for the petitioner, and also heard Mr.
N.K. Neog.
M.K. Deuri.
N.K. Neog.
N.K. Neog.
Neog.
What's it?
Respondent
Learned
1 and
counsel
3.
for the respondent number 1 and
3.
1 and 3. Who is for respondent number 2?
Respondent number 2, actually, Your Honor, Lordship,
They are actually not conflicting.
because they are already expert in the trial.
They are
Acha,
expert.
acha,
I get them
acha. This application under Article 227 of the Constitution of India is referred by the petitioner, Sri Prahlad Singh and Sri Manish Rai, challenging the correctness or otherwise of the order dated 4/8/2023 passed by the learned civil judge number 3, Kamrup M. Guwahati, on the petition number 4363 of 2022 filed by the plaintiff under Order 7, Rule 14(3), read with Section 151 of the Code of Civil Procedure for filing additional document. It is to be noted here that by MP on order dated, the page number is
Order dated, Your Honor, Lordship 4/8/23.
4/8/2023, the learned trial court has dismissed the petition on the ground that the plaint contains no plea whatsoever regarding filing of the income tax return of the plaintiff for any assessment year. And as such, the additional documents sought to be filed by the plaintiff are beyond their pleadings and therefore rejected the petition. Mr. Sharma, learned counsel for the petitioner, submits that in the written statement submitted by the respondent number 1, 1 and 3 as stated that after signing of the agreement of the plaintiff stated that as per income tax department notification, they cannot pay a sum of rupees 5 lakhs in case, and they will make payment of the payment by bank transfer within a week. However, plaintiff did not make any payment. And since a specific plea is taken in the WS counterclaim filed by the respondent number 1 and 3, the plaintiff is required to file the income tax return. He will file a reply to the counterclaim.
They may file reply. We have already filed.
Already filed. And that he has already filed a reply to the said counterclaim. And in view of the averment made by the petitioner, made by the respondents in the written statement counterclaim, the petitioner may be, the plaintiff may be allowed, the petitioner is the plaintiff may be allowed to file the income tax return. On the other hand, Mr. Now learned counsel for the respondent number 1 and 3 submits that there is no averment in the plaint regarding filing of any income tax return. And as such, the learned trial court has rightly dismissed the petition. But having heard the submission of learned advocates about the parties, I have carefully gone to the petition and the documents placed on record, and also perused the impugned order dated so and so. It appears that the learned trial court has rejected the petition on the ground that no averment was made in the plaint by the plaintiff, by the petitioner struck plaintiff for any assessment year. Now, regarding filing of income tax return in respect of any financial assessment year. And therefore rejected the petition. But it appears that in counterclaim, written statement and counterclaim filed by the respondent, a plea is taken. No, in the written statement of the plaintiff against the counterclaim filed by the defendant number 1 and 3, a plea has been taken regarding payment of rupees 5 lakhs at the time of execution, and the same has been shown in the income tax file of the plaintiff. And in that view of the matter, the reason for dismissing the petition filed by the petitioner by the learned trial court appears to be illegal and arbitrary, and as such the same cannot be allowed to sustain. Accordingly, the order dated 4/8/2023 is then set aside, being arbitrary and illegal. The learned trial court is directed to allow the petitioner to file the income tax return. For the assessment year,
The 100 is mentioned. The petition. My lord, I'm sorry.
17, 18 and 18, 19,
My lord.
17.
right?
My lord.
17, 18 and
18.
2017-18 and 2018-19. In terms of above, this CRP stands dispose of.
Obliged.
Item 58.
May it pleases you lordship, on the earlier dated your lordship 14/8/2024, your lordship, as per the order dated your lordship 14/8/2024, we have taken steps your lordship. Notice has issued upon the sole respondent through registered post. But till date, your lordship, as per 11/9/2024 order dated, your lordship, neither AD card unserved notice received back for sole respondent. So service may await it, your lordship.
Awaited. Heard
And your
is
lordship,
Peters,
one
Learned
stay
Counsel,
is stay.
Learned Legal Aid Council. Office note dated 11/9/2024 indicates that neither AD card nor unserved notice issued to the respondent returned to the section till date.
Your lordship, one stay interim is there, your lordship.
Accordingly, it is provided that recessal list the matter after 2 weeks awaiting service report upon respondent number.
Sole
Upon
respondent.
sole respondent. Till then, interim order passed. Interim order, if any, pass earlier shall continue. Where it was passed?
On dated,
14/8.
oh, yes, your lordship, 14/8/2024.